Please.
At this time, ladies and gentlemen, the jury, the defense rests.
All right. Mr. Lewis,
This time the state would like to offer rebuttal testimony on.
go ahead.
State calls Mark Johnson.
Mr. Johnson, if you would please come to the front of the courtroom. And before you have a seat on the witness stand, I'm going to swear you in front of the jury. You could raise your right hand. You swear the testimony that you're about to give will be the truth.
Yes.
All right. You can have a seat, please. You'll be responding to questions from Mr. Lewis. And whose witness will this be for the defense? And perhaps Ms. Matson. Whenever you're ready, Mr. Lewis, you may proceed.
Thank you. Good morning, sir. Could you please introduce yourself to the jury by stating your name and spelling it for the court reporter?
Mark Johnson, M-A-R-K, J-O-H-N-S-O-N.
Mr. Johnson, how are you currently employed?
I am the president of Visual Law Group. We are a forensic consulting company. We do data analysis, photogrammetry, and other technical tools to provide data for other experts who are testifying in cases such as this one.
Okay, and what's your educational background?
My technical background goes back to probably the earliest workshop on photogrammetry and visual science was back in the 90s with Dr. Arthur Ginsberg. I then also was an instructor at an accredited technical college and then later became the chairman of the multimedia department where I taught digital video, computer animation, and also hired and fired instructors.
Okay, and how long have you worked in this particular field, sir?
Well, almost 30 years. I have consulted for a number of the hardware and software companies that provide equipment and software used by law enforcement and technical experts. I have also trained both law enforcement and forensic technicians and engineers in areas of photogrammetry, drone mapping, and also digital video analysis.
Okay. Do you have any special training or instruction with regards to these fields of expertise?
Well, I've helped develop some software tools for a couple developers in which we are currently integrating laser scanning and other metrology for the purpose of analyzing crime scenes and disaster scenes. I have consulted as a trainer and as a curriculum advisor for a couple companies that produce training for law enforcement and for engineers. I've written a number of articles and done presentations as well as a couple chapters in some forensic publications and textbooks.
So you mentioned photogrammetry. Can you describe and explain what that is for the members of our jury?
Photogrammetry is a big word that really means deriving accurate measurement or accurate data from photographs or from video or film. And it operates on the theory that when we use a camera, the lens is collecting information on very basic laws of physics, and we can reverse engineer what the lens sees to tell what the camera was observing. So the best example would be if I have 3 photographs of an object taken from 3 different locations, we can use computer software to calculate where that object is in 3-dimensional space. So in this particular case, we were asked to look at velocity of the vehicles, and we used a number of tools to provide that information to you.
And you also mentioned digital video analysis. process? What does that entail?
Well, back in the 80s, when digital video first became available generally, it changed a lot of the way we operate in forensics, because digital video operates at a very specific definable frame rate. In this case, we have body cameras worn by the officers. Those cameras are operating at 29.97 of a second, or frames a second. So just less than a 30th of a second, there's a new image taken by the body camera. So digital video allows us to have a very specific time record of events recorded. If the camera is good, which it was in this case, then it's a matter of just collecting the distance accurately. And from your old junior high science class, you may remember that if you have time and if you have distance, you can derive speed or velocity.
What is a 3D model, and why is that helpful?
Say that one more time.
3D CAD model?
Okay. 3D CAD. CAD just stands for computer aided design. But also since the 80s, everyone from engineers to architects to surveyors have begun working with computer modeling programs, and that was the same thing for me. I became very interested in that back at the advent in the 80s. And this is a way to create scene accurately in a virtual model. Virtual model of the scene where the events took place. That allows us to make measurements that are accurate. It allows us to recreate what the officers saw. It allows us to recreate what opposed to having to put on your training. I have a chapter in a railroad forensic textbook. I have a number of white papers where I've written for engineers and for forensic technicians, and I also then present regularly at conferences and at training seminars.
Are you a member of any professional organizations within these fields of expertise?
Yes, I'm a member of the IAFSM, and that stands for International Association of Forensic and Security Metrologists, and that's another big word that I don't know who named it, but what it basically means is anybody interested in deriving measurements and data from crime scenes or disaster scenes will be benefited from this organization. We perform workshops, we certify people in some areas, and we have been, we have a conference every year. In fact, it's coming up this year, where we are looking at laser scanning and particular elements of crime scene analysis.
Now, obviously in this case, you were asked to do some work for the prosecution, is that correct?
That's correct.
Now, on prior cases, let me just ask you, have you testified in court before as an expert witness in these fields?
I have. I don't testify as often as a lot of expert witnesses because we usually are providing data that's used by the guys who are the number crunchers or the opinion experts. We think of ourselves more like a surveyor, where we are collecting accurate information, and whomever hires us, data is data, and we use the same techniques, and we try to collect and provide data that can then be used by the people who can derive opinions and testimony, such as this case. We have an accident reconstructionist who's an engineer who understands the way those numbers are calculated and applied.
Okay, so you're asked to work for the prosecution in this case, but on prior occasions, have you worked on the defense side as well?
Yeah, we have almost a 50-50 mix working for prosecution versus defense. We also do a lot of cases on the civil side where airplane crashes or trucking disasters, and we almost always work 50-50 there. And it's just, you know, we are professionals. We'll work for whoever retains us, and we like to hold ourselves out as being agnostic. If you hire us, we'll give you the accurate data, and no matter who hires us, we try to apply that standard.
And obviously, you expect to be paid for your work, is that correct?
That's correct.
What is your rate?
My rate is $350 an hour, and then for courtroom testimony, it's $450 an hour.
So if you can give the jury a ballpark of how much you expect to be paid in total on this case.
You know, I think it was very tedious because of the work we had to do, which I presume we'll get into, but it's up at $16,000 or $17,000 at this point.
Now, with regard to what you were asked to do in this particular case, describe for the jury what that was.
When we were approached, the question was put to us was, is it possible to accurately determine the velocity of the vehicles that were moving in this case? And to do that, as a forensic technician, you approach it from a number of different means. Sometimes you have a black box in the car that will show you the velocity. We didn't have that, or if it existed, it either was not valid or certainly wasn't provided to me. So what I was provided were 5 body cameras that were taken at the scene when the events were taking place. I was also given a laser point cloud that was produced by the Texas Rangers. And interestingly, the organization I mentioned that I'm part of is actually one of the main officers is a Texas Ranger, so I have had some opportunity to learn about them and the equipment they use. And they use a very good system produced by a company called Leica Technology, and they went out to the scene a couple weeks after it happened, and they ran the laser scanner. And what this is a device that sits on a tripod, and it shoots a laser beam at 360 degrees millions of times, and every time that laser strikes an object, it reports back to the software where that object was. So when you are finished, you have a complete 360-degree replication of everything the laser saw. Now, you can't see behind something, but everything that you can see, you can measure, and if you want to get the information behind an object, say behind a fence or behind a car, you just move the laser scanner over there and you run it again. You combine all of these together, and you can actually, now that we have the software that we use, you can put on your Oculus goggles and you can actually stand and look as though you were in the scene. And it's really a useful tool that's kind of space age or technical, where you can actually measure objects and you can view objects and see what's available to be seen within this virtual reality. So in this particular case, the Texas Rangers produced a laser scan, and my first job is to make sure that that is accurate, because believe it or not, sometimes people don't operate equipment appropriately, and sometimes the results aren't accurate. So I had all of the scene photographs, I had the body cameras, and I came to Dallas and I did my own laser scanning session, and I also flew a photogrammetric drone, which is a calibrated drone camera that acquires photogrammetric information so that we could have the entire apartment complex created. Once we, I'm sorry?
Stop for 1 second.
Yes.
Just so the jury is clear, what exactly did I ask you to do in this case? And we'll get into
Yes.
what you did later.
I was asked to find accurately what the velocity of the vehicles were and where the officers were throughout the sequence. And to get there, you have to acquire all of this information. Now, you could look at it and say, well, I think that's 2 miles an hour, but obviously that's as good as the opinion that I have, and we had to rely on a very sophisticated scientific analysis to figure out what the data was that could be the basis for determining that velocity.
And so with regard to the information that you were provided, you already mentioned the 5 body-worn cameras, is that correct?
That's correct.
You had some crime scene photographs.
We had the crime scene photographs, and these were important because they show both of the principal vehicles, the patrol car and the Dodge Journey. They show them where they came to rest. And the officers took a spray can and marked the tires for those vehicles, and they also marked a couple other objects. They marked where the door of the patrol car was open. They also marked the tires for a Chevrolet Astro van that is there at the scene. So those paint marks actually show up in the laser scan. So now we can really precisely to a fraction of an inch tell you where these vehicles came to rest.
Okay, you also mentioned Detectives Rangers doing a 3D scan of the scene with the Leica, is that correct?
That's correct.
You had mentioned a point cloud. Can you describe for the members of the jury, what is a point cloud?
Yeah, as I explained, it was every point that that laser touched. If we set the laser scanner in this courtroom and I ran it, we would turn on the computer screen and you all would be visible in there, except if you moved. If you moved your head, you might have two heads while the scanner is moving around. But for objects that are fixed, the jury rail, the desks, the lights, anything that is not moving is accurately determined. So in this case, of course, we make sure nothing is moving to block the scanner. In this case, we have a three-dimensional representation of the fence, the marks of the tires on the ground, where the carport is. Every object that is visible as being unmoved in those scene photographs is very precisely located now within the point cloud.
What other information was provided to you for your analysis in this case?
We were given the crime reports. There's some incident reports with diagrams that were drawn by the police department. We had the affidavits of the officers. We were also given, let me think if there's anything else in our list. I mentioned the crime scene photographs and the body cam videos. I think that was what we were provided.
Okay, and you had also started to describe some new information that you gathered. You had mentioned going to the scene independently and doing a 3D scan of the scene, is that correct?
That's correct, and we also went to where the Dodge Journey vehicle is impounded, and we did our own laser scan of it, because as you will find out, it becomes very important to know the length of that vehicle and the diameter of its tires in order to derive the velocity it was moving.
Okay, any other new data? Did you actually go to the scene with one of the body-worn cameras in this case?
Yes, we wanted to know where the officers were, and the best way to do that is to determine what the camera is seeing. So I was graciously provided a body camera of the same model used by the officers. We took it to the scene, shot footage with it, and then ran the laser scanner. So now we not only have a laser scan of the scene, but we also have the same scene seen through the body camera, so that we can very precisely determine what the body camera is seeing. Then finally, we did a series of tests with the body camera using a spatial grid, so that we could then run it through a software program to see if the lens has any distortion or any defects. If it does, we can correct for that. And once we were done in this case, we found that these are very, very good cameras with a very appropriate and high-resolution optical system.
So with the data that was provided to you, in addition to the new data that you gathered, what exactly did you do with that information?
Well, we started out, and again, the objective here is to decide how fast are these objects moving that we see in the video. Second objective is, where are the people who are taking these views with their body cameras located? So we started with the three-dimensional scene, and we converted that to the CAD model, and that's a accurate computer model that lets us, simply, it's like being a 12-year-old kid with cars, and you can play with them in the computer. But in this case, it's a very precise, accurate model of what the crime scene was. We then looked at the digital video itself. So there's a couple processes, and I'm going to explain them to you. The first is, we can see in multiple cameras the wheels turning on the Dodge Journey. And the Dodge Journey wheels have spokes. You can see, I believe it's six or eight cavities. So you can see the wheel turn very clearly when the body camera is not shaking. Back in your physics class, if you're like me, you can barely remember, but pi is the function that if you know the diameter of a wheel, you can figure out the circumference or the tread. So in this case, we can see the wheel turning, we can count and track that rotation. Now all we have to know is the precise diameter of that tire, and we can tell you how fast that tire is moving. So we did that on several segments, and we looked at the tire diameter both on the laser scan and on the manufacturer's specifications, and we found out that this tire is a very specific diameter, which I don't have committed to memory, but Mr. Partain can certainly talk about it. And we were able to calculate speed of this vehicle using rotational velocity, and we determined in several points that essentially this vehicle is moving at walking speed. We also looked at that same question and said, let's look at it another way. And we took all the body cameras and we measured photogrammetrically where the car was when it's against the fence, where it is at the next interval, and we used the CAD model to create a three-dimensional analysis of the motion of both the patrol car and the Dodge, and we were able to calculate velocity completely separate from the rotational velocity. The bottom line was it came out consistently. Once again, we're looking at speeds of 2.5, 3 miles an hour for the motion of this vehicle. Finally, then, we looked at the video itself and stabilized it and put the fence in the background so that we can see the car moving across the fence. We know exactly what the dimensions of this fence are because we have the laser scan. We also know the dimensions of the Dodge Journey because we have it scanned. So now we can study at every 30th of a second where that car is moving, and we can then derive the velocity that way. So the reason it's so expensive is this is a tedious process, but we looked at it from 3 different approaches, and we came up with the consistent velocities in this case.
Now, with regard to the demonstratives that you put together for this jury to see today, how many of those was it?
We produced 3 different short clips that we felt would be helpful to explain the information that we derived in the case.
Mr. Johnson, I'm going to show you what's been already admitted for record purposes at this point. State exhibit number 139, 140, and 141. Can you tell me whether or not you recognize those?
I do.
Okay, and are these the demonstratives that you put together?
Yes, and we confirmed that and viewed each of them. Those are the demonstrative exhibits we produced.
Okay, just for the record, 139 is rotational average velocity with timer.
Correct.
140 is sync with camera views.
Correct.
And 141 is velocity positions time to shots.
Correct.
And you had an opportunity to view these videos prior to your testimony today.
I have.
Do they fairly and accurately represent the demonstratives that you put together
They do.
during your analysis?
Yes.
And would they be helpful to the jury to understand your testimony today as it pertains to the position of the officers as well as to the velocity of the victim's vehicle?
I do believe it would be helpful.
It's time the state offers 139, 140, 141 all persons 10 to come.
It's admitted. You may publish.
So let's start with state exhibit number 139, rotational average velocity with timer. And before we show it to the members of the jury, if you can just kind of describe what are they looking at on this particular exhibit?
Well, with this particular video, you're going to see, and I believe this is at slow motion so that it's easier to detect. You're going to see the body cameras, there'll be 3 of them, from 3 different officers, and they've been synchronized so that as the video is playing and we're seeing the same view from 3 different cameras. There's a timer so that you can see the time counting down to when the first shot is first fired. And at intervals, you'll see us track the rotation of a wheel, and then a value of average velocity will flash on the screen. So that's the average velocity the vehicle is going at that interval. So you can play this and look at the time, and you can see the views of each officer, and you can also see what the movement of the vehicle is. It is at slow motion, and so if it's played with audio, it'll sound strange, and that's because the dispatch audio is 1/4 of the speed of normal speech.
Public proceeding states exhibit number 139, rotational average velocity with timer.
If you look in the upper left-hand corner, you can see that wheel being tracked, and you can see the velocity there was 2.1 mile per hour average. Now the front wheel comes in and it's slightly faster, 2.5 miles per hour than 2.8. So I'm sorry, this one doesn't have the countdown to the shots. That's on the other video. But that timer that you see there, that is simply an accurate time code. It's reading what the video frames are telling it. So every 30th of a second, the frame is updating, and we've slowed that down, so now it's 1/4 of that speed. So obviously 1 second takes 4 seconds when you play it at this speed.
You talked about it being slowed down. The audio that we hear on there sounds kind of distorted, and I think you kind of described that that's because it's been slowed down.
That's correct.
Can you describe for the members of the jury what audio are they hearing on this video?
You're hearing the actual radio traffic that is being collected on the body cameras, and when you play it at real time, of course, you'll hear the officers talking. Now it's slow motion, very low, but if you listen carefully, you can make out the words, and of course, you can hear the first shot fired there because it's a very prominent spike in the audio signal.
So the audio is the officers talking. Is that correct?
That's correct,
Okay.
with the exception of then the bullets that you hear.
Okay, as well as the shots being fired in the video.
That's correct.
All right. So with respect to the moment in time right before the shots, what kind of velocity are we talking about with respect to the victim's vehicle?
We're under 3 miles an hour, and I believe just short before, I think it was average velocity of about 2.8 miles per hour.
So when you say average velocity, what does that mean?
Well, when I move my hand, if I'm moving it at a constant speed, say 1 foot per second, then there's no problem. It's always going at 1 foot per second. But if I accelerate it or slow it down, that velocity is changing over time. And I can move it like this, and to get a sense of what the true velocity is over an interval of time, you average its motion. And so that's what typically experts in this field do. If you look at a very momentary instant from one frame to the next, you can be deceived because there may be a slight jitter in the frame or the pixels. So we always try to work with average velocity to be more meaningful. So in this case, the velocities are in fact low, and they're within the what are the parameters of human walking speed.
So next we're going to take a look at States Exhibit number 140, which is going to be synced with the camera views. And if you could describe what the jurors are about to see on this particular exhibit.
Okay, this one you're going to see the computer CAD model. So you're going to see the actual virtual model of the scene that we created. And on the left side of the screen, you will see 3 of the body cameras in sync with what you're seeing. But the main part of the screen is going to be looking straight down on the computer model, and you'll see a timer that counts down to when the first shot is fired, and you will see the velocity being derived instantaneously as the vehicle is moving. So as we're looking down, you'll notice the velocity of the Dodge is in the upper center of the screen. Now it's just started backing up, and it strikes the patrol car, and it's going to go forward into the fence. Now it's going to back up the sequence, and you'll see that the first shot is now 4 seconds away, 2 seconds, car stops after the first shot are fired, and then it rolls back again. And you can track the velocity throughout the motion by just looking at that scene.
This demonstrative also contains the position of the officers based upon your analysis of their body cams, correct?
Yes, as you've heard testimony in this case, the officers were in different locations, and you can follow their motion over the time and in relation to when the first shots are fired.
So we'll watch State's Exhibit 140 again.
And we've removed the carport to make it more obvious and easy to see where everybody is. But
I didn't mean to cut you off.
it's gone, it's fine.
Okay. So at this time, we're going to focus on the officers' positions, okay?
Okay?
Back up.
Have you ever had like secured their uniform and armed?
Don't move!
So based on your analysis of all the body-worn camera evidence in this case, as well as the demonstrative we put together for the jury today, fair to say that the officers who were behind the vehicle initially were no longer there at the time the shots were fired?
You know, based on the photogrammetric analysis, this is where the officers were. Yeah, to my eye, they definitely are not behind the car when it moves, but I'm not expressing an opinion on what that means. That is where they were, and that's our purpose, is to show you accurately where everybody is at throughout the duration of this sequence.
So on this particular demonstrative, what velocity are we talking about for the Dodge journey right before the shots were fired?
Well, again, this is computing the velocity on a moment-by-moment basis. So it shows here 2.4 miles per hour. That's at that instant. Over time, though, as you watch it, it's slightly above, slightly below, but the bottom line, and what I try to tell people to think about it meaningfully, human walking speed is considered 3.1 mile per hour. Is what, if you put somebody in a room and you just say walk, that's the preferred walking speed as determined by biomechanicists. So if walking speed is about 3 miles an hour, the movement of the vehicle in this case is at or below that throughout the sequences we're looking at here.
And finally, we'll look at State's Exhibit number 141. This one is velocity positions, time shots. What are we going to see in this exhibit?
Well, this sequence opens up with a view obliquely of the three-dimensional model. When we first began working on this, we weren't sure what was going to be relevant. So we actually modeled out the full apartment complex. And you'll see, when this one opens up, you'll see a view so you can see the orientation of the whole model. And then the camera is going to go up to the overhead view, the same overhead view we're looking at here, and we're going to see the same sequence with velocity in relation to the computer model. So here's the full three-dimensional model that we built. Now we're going to dissolve away the carport, and we can now see the same motion of the officers. But this one gives you a little bit better orientation of where everything was.
Back up.
Have you ever had like secured their uniform and armed?
Don't move!
What software did you use to create these demonstratives?
We use several tools, but the primary computer CAD tool was made by a company called Autodesk, and it's called 3D Studio Max. It's used commonly by everyone from the National Transportation Safety Association to the major law enforcement agencies, and engineering firms. We also used a series of video calibration tools to calibrate the video and look at the body cameras, and we used a number of the Adobe software packages you may be familiar with, Adobe After Effects, Adobe Photoshop, and we used a product called Input Ace, which is a particular video analysis tool used by law enforcement and the government.
So with regards to the tools that you use, they have been used other governmental agencies as far as
Yes, these tools now are to the point we used in the association that I work with. We used to keep a record of the software and the cases that it was introduced in, because it was important to establish that these tools are accurate. Several years ago, we stopped doing that because we had hundreds of cases with these particular software tools. Both laser scanning and three-dimensional computer modeling are now not only established, they are pretty much a prerequisite, because there's no better way to accurately get reconstruction data these days.
So again, with regard to the validity of the velocities that you came up with on these demonstratives, you actually did it in different ways with regard to tracking the tire movement, is that correct?
Yes, we rotated the tire, we looked at photogrammetric positioning, and we stabilized the video and compared the movement of the car against a known background object.
And you consistently came up with the same results?
Yeah, you get variations. If I measure that television monitor with two different yardsticks, I'll get a different result. Not because the yardsticks aren't accurate, but because there's always an amount of variance typically. So in this case, what we're interested in is not, can we replicate the results, are we going to get consistent results? And in this case, we got consistent results. I have no problem expressing confidence in this data.
And you also mentioned that you had your information checked again with respect to an accident reconstructionist, making sure that these velocities were correct.
Yes, I will have to admit, I'm not the greatest with math. I can run the computer extremely well and I understand concepts, but my checkbook may not be balanced properly. And I don't have an engineering degree. I'm very knowledgeable with what I do, but when it comes to calculating or to actually establishing accident reconstruction, we almost always work with someone who uses our data and then can express those opinions, and they can answer the hard questions about why is this motion calculated at this particular way. So we provide the data, and in this case we provided the data to a qualified accident reconstructionist to confirm both the accuracy of our techniques and the accuracy of the velocity calculations that the computer created.
And who was that individual that you worked with?
That's Mark Partain. He's from Fayetteville, Arkansas, and he has agreed just this year to start consulting with us, because we have found our clients often need these services, and rather than having to wait for them to engage someone, if they require it, we have someone now that we can trust and that we provide data to.
And were his conclusions consistent with your conclusions on this case?
They were.
Thank you. Pass with Sean.
Cross-examination. Yes, ma'am.
Ms. Johnson, fair to say your bill is over $20,000 at this point?
I'm bad at math, as I said. I haven't calculated it, but that sounds like the case, yes.
But when you gave it to me at the beginning of the week, it was $19,650. And since you are $450 an hour to testify, you're over $20,000.
Well, I think I put on there, I estimated a 4-hour testimony, which I haven't looked at my testimony. I'd have to go back and see how much over, but if you say so, I won't dispute that.
That's a fair representation, isn't it?
Yeah, I just gave you my hours and my rate, so I didn't add up the total, or if I did, I don't have it by memory now.
And you had Mr. Partain check your math, and he would have billed for those hours separate, correct?
He bills separately for me, yes.
Did the state make you aware that you are the second group of experts they hired?
No.
Did they tell you that they had hired an expert to do speed calculations well before you?
No.
Did they tell you that expert had the speed almost twice as much as your speeds were?
They didn't tell me that. I've since, through this trial, learned that there were some calculations that were not done appropriately.
Well, they hired somebody and had speeds twice as much as yours, didn't like that, and then engaged your services. Were you told any of that? Were you told any of that, that you were the second group of experts they were hiring to make these calculations?
Well, when I was hired, I was asked to perform this task. Since this time, I've learned that there was a gentleman who did kind of a back-of-the-envelope estimate, and his approach was not acceptable by the terms of velocity determination. So I didn't know that until this trial, but I can certainly see why those estimates were not accurate.
You learned it from me, you didn't learn it from the state, did you?
Well, I think I learned it from being in the courtroom.
And me, my witness, who I
Oh,
called.
I didn't know whose witness it was, but if you say so.
And you actually had to slow things down. Your phrase was, so it's easier to detect. You had to slow it down to the jury for it to make it easier for them, correct?
No, it slowed down to be able to see the tracking more easily, but it's not any different information.
It's not any different information, but in order for the jury to actually see what you wanted them to, you had to slow the time down, right?
Well, I didn't have to, but I thought it was helpful given that we're looking at a very short interval of time here.
And we are, for every second, you made it last 4 seconds. Is that what you said?
Well, the computer slowed it down 4 times, yes.
And you talk about walking speed. You would agree with me that the speed of this car changed several times, didn't it?
Well, it's constantly changing.
Constantly changing, and constantly could keep changing, couldn't it?
Well, it's changing within a walking speed parameter. All of these velocities, you can see yourself, are within a narrow range.
Because there was a narrow space to maneuver in, right?
I'm not following that, I'm sorry.
Well, the first time it moves, when it goes back into the squad car, they don't have a lot of room to get momentum, do they?
That's correct.
But you would agree with me they're gaining momentum as they hit the squad car.
You know, I think Mr. Partain could probably comment on that too. Certainly, I don't believe the acceleration is very high. So it's not as though they slammed on the accelerator.
And then you see when the car rams the fence, when the driver rams the fence, you would agree that they're gaining momentum in as small an area as they can.
No, I mean, they could have blasted into that fence, but they went at a slow speed.
You think they weren't trying to ram down the fence?
Why? That's outside of my expertise, but I know that the velocity that we see, as you can see on the video and as you look in the velocities, they approach the fence at a slow rate.
And when they put it in reverse
Mhm.
and back up where the officers are, you were trying to show where those officers are at that time, correct?
Well, I think the demonstrative showed that, yes.
Okay, and your reason for creating that demonstrative was in order to accurately show this jury where the officers were, right?
Yes.
And in order to do that, you had to slow it down so that every second lasted 4 seconds.
No, the purpose of we don't do anything with where the officers are where we slow it down. There's only one exhibit that is slowed down, and that is simply looking at the rotation of the tire. Both of those other exhibits are at real time. So when you look at those, that is the motion of the car. And you can see it by comparing the camera, which is also on the left side of the screen. And that's at real time. That's not slowed down.
Okay, so you created one exhibit where you slow it down.
For the rotation of the tire, yes.
Every second lasts 4 seconds. You created one exhibit where you slowed time down for them, right?
For the rotation, yes.
And then you created another exhibit where you make it well lit.
Well,
It's all the same lighting in your exhibit, isn't it?
okay, I'll give you that, yes.
It's not like it is on the body worn cameras. It's not dark, it's not shadowy, there's not a bunch of leaves on the ground.
Well-
It's a well-lit diagram.
Yes,
And you remove the carport.
yes.
Officer Hess didn't have the benefit of that, the carport was there. And you remove the other cars that are in the way, right?
Well, the cars under the carport are not there. Yes, those cars were there at the scene, but our purpose was to show clearly the velocity and motion and the relative positions.
And in order to do that, you had to make it well lit, remove the carport, remove the other cars, and slow it down by 4 seconds.
No, the 4 seconds is, the 4 times slow motion is only the rotation of the tires.
Mr. Johnson, you took 51 hours in preparing this case for trial, correct?
That's correct.
So you took 51 hours to create for this jury what Officer Hess had 4 to 5 seconds to calculate, didn't you?
I don't think that's fair, but if you want to phrase it that way.
Well, that's what you did, right? You took 51 hours.
No, I came to Dallas twice. I did extensive scanning. I did extensive analysis in 3 different modalities. You can't get this, particularly with low velocity cases, you can't get this level of accuracy without spending time.
And Officer Hess didn't have the benefit of that night, did he?
Just a speculation. You can answer.
Officer Hess had the time that is, you can see on the demonstrative exhibits that we produced.
And you were in no way telling this jury that you can predict the future, are you?
I wish I could.
You know what I'm getting at. You were not saying whether or not the person in that car was going to accelerate out of that parking lot through officers. You can't tell the jury that, can you?
Well, I would never presume to tell the jury what somebody's going to do. I can only show you accurately what the facts were.
And in order to do that, it takes you 51 hours, 3 diagrams, removing the carport, making it well lit, removing the cars, in order to accurately show the jury.
Well, I'm proud that we were able to get the work done the way we did, and I'm happy to stand by it.
That's the witness.
Just very briefly, Mr. Johnson, I'm going to show you a couple of documents and you tell me whether or not you've seen this before.
Yes, I have.
Okay. So when the defense counsel asked you, and you made aware that there were some other calculations in this case, you were aware of that, correct?
I was aware of those documents, yes.
And I made you aware of those, correct?
Yes, you did.
Okay. And we discussed these, didn't we?
We did.
And we talked, well, you tell me, what are your thoughts on those calculations?
Well, those calculations are not only incorrect in terms of documenting. I believe that they, in some respects, describe an acceleration that physically was impossible by this car. Now, I'm not an expert in that area, and Mr. Partain can certainly talk about it, but I know what the officer did who made these calculations, and it was completely unacceptable and inaccurate as a means to accurately reconstruct the velocities of this vehicle.
And with respect to the individual who created these calculations, you had made allusions that it was an officer. This was Detective Ernest Embry with the Dallas County Sheriff's Department. Were you aware of that?
I became aware of that, and I was aware of what he said he did to create those measurements.
Okay. Talking about using a stopwatch, is that correct?
Yes, he apparently was looking at the video. If you play this video on any of your computers, whether you use the Windows player or the QuickTime player, you can see seconds and frames, but apparently whatever tool he had to play the video only gave him a second at a time. So he's trying to calculate duration of the movement of the car by looking at a video that the counter only is reading out seconds, and he's clicking his stopwatch with his finger as he's looking at the video when the car stops and when it stops. And then for measurements, he measured the width of the panel on the fence in the background as I think about 8 feet, he said, and he tried then to estimate the time and the distance. And as I said, if you know time and distance, you know everything about the velocity of this car. This gentleman did not know the time accurately, and he did not know the distance accurately. So it's not surprising that his calculations were, I guess, twice of the velocity we calculated. Our velocities are accurate. That's what the video shows. Those calculations are not.
Thank you. Pastor Rich.
Ms. Manson?
So when you introduce the human error, the human part of it, what the human brain is able to do, it's not at all surprising that he was able to estimate speeds that were twice as much as yours.
Well, anybody who's trying to look at a video in the field and using a stopwatch is going to have a hard time accurately recording time or distance.
Because it's a little more like what the human brain does in real life, isn't it?
I wouldn't accept that.
And it's going to be like twice as much, isn't it?
Well, it could have been half as much. I mean, it depends on where the error was.
That's the witness.
No further questions, John.
May this witness be finally excused. Very good. Sir, you may stand now. Mr. Lewis, call your next witness.
State cause Mark Partain. Sir, will we please come to the front?
When you have a seat, you can raise your right hand. You swear the testimony you're about to give will be the truth. Yes, sir. All right, please have a seat. Respond to the questions of Mr. Lewis, and that's also Ms. Madison. To your left, you may proceed to the middle.
Thank you, Your Honor. Morning, sir. Could you please state your name and spell it for the court reporter?
My name is Mark Partain, M-A-R-K-P-A-R-T-A-I-N.
Mr. Partain, how are you currently employed?
I'm currently employed at a company in Fayetteville, Arkansas, EI Consultants. I've been working there about 20 years in April. And as Mr. Johnson mentioned, this year EI Consultants has encouraged me to start offering testimony on my own, and has allowed me to consult with Mr. Johnson's company, Visual Law.
And what is your educational background, Mr. Partain?
I have a bachelor's and a master's degree in engineering from the University of Arkansas. And as far as accident reconstruction specific education, there is an organization called ACTAR. They are there for people in the reconstruction community to take an exam, and if you pass this exam, you've demonstrated your abilities as an accident reconstructionist, and they'll assign you a number, and then you have your ACTAR exam passed. I've taken a number of accident reconstruction related courses through the Society of Automotive Engineers and other organizations that deal with accident reconstruction as well.
Okay. Now, how long have you been in the field of accident reconstruction?
I got started when I started at EI Consultants, and so that's been about 20 years ago.
Okay. Have you authored any publications or articles in your field?
I've participated in publishing a few articles related to different accident reconstruction topics, yes.
And what is accident reconstruction, just for those of you?
Well, just as a personal definition, I would say accident reconstruction, a client will come to you and present a situation and ask a question. Then it's your job to go out into the field and collect data, whether that's inspecting, say, the accident site, looking at the accident vehicle, collecting reports generated by police departments, looking at accident scene photographs. You want to collate that data in a manner that you can do some math and analyze it and try to arrive at the answer that you were asked in the first place, and that's primarily what you do as a reconstructionist.
Have you worked with laser scanners before?
Yes, sir.
And Mr. Johnson kind of described what they do. How accurate are these laser scanners?
We purchased our first scanner a number of years ago, and at that time Faro told us they were, Faro is the company that manufactures the scanner we use. I just thought you want to know. But they said that the scanner is accurate to 2 millimeters over a distance of about 20 meters. And if you're not really familiar with the metric system, 20 meters is about 65 feet, and there's 25.4 millimeters in an inch. So you're looking at about 2/12 of an inch over 65 feet is how accurate they are.
Have you had experience determining velocity in forensic cases before?
Yes, sir.
On how many occasions?
Since I've started at EI Consultants, I've estimated I've worked on somewhere around 500 to 1,000 cases. majority of which of those have been automotive-related cases and involve speed calculations of some sort.
And what were you asked to do in this case, Ms. Fontaine?
I was asked primarily to look at wheel rotation information Mr. Johnson obtained through looking at body cam footage from the police officers and calculate vehicle speed based off of those wheel rotations.
Okay, and tell the members of the jury about your analysis in this case and what were your results?
Okay, if it's helpful, I could, draw a diagram over there if that works, or is that okay?
Sure.
Well, you need, as Mr. Johnson said, you need two components to get speed. You need time and distance. The time portion is already covered by the police body cameras. We know based on that 29.97 frames per second. So from that, that every frame is a little bit less than 1/30th of a second. Maybe I can just explain. So the size of the tire, you want to know the diameter of the tire. In this case, it's 29.3 inches. And we know that from specifications on the tire. You can also calculate it based on the tire size. We know it's a 225/75 R16 tire. Those dimensions, the 225 is the tread width in millimeters. Got 225 millimeters tread width. 75 is the percent of that in sidewall height, which is 6 point some odd inches, and then the wheel is about 16 inches itself. So from those numbers, all right, I can't draw a circle. So we have a 16-inch diameter wheel there, and I just told you how we calculate the height of the sidewall here. We have two of those, the top and the bottom. So we add two of the sidewall heights to the wheel there. We end up with 29.3 inches diameter on that tire, which matches the scans and the specifications of the tire. And as Mr. Johnson already mentioned, you multiply that 29.3 by the constant pi, and that will tell us the distance all the way around a tire like this. So once you know the circumference of the tire, as the tire rolls along, I'm sure all of you guys have used a tape measure, and as the tape measure comes out, the wheel spins, and then the tape measure comes out, so you can imagine the tire rolling along the ground, and it's working just like a tape measure for us. So we got the time from the officers' body cameras, we had the distance from the circumference of that tire, and that's how we calculated the speed off of that.
Ratio 142 is the next row.
Statement of office statement is 142 for demonstrative purposes. Any objections? It's admitted. So you just described for the member of the jury how you came up with velocity based on the diameter of the tire and using timing based on the body-worn cameras. What results did you come up with?
Well, the primary focus was to look at the speed of the car from the time it left the fence as it rolled backwards towards the time that the first shots were fired. We looked at a few segments of the body camera footages, I think there were 5. We obtained speeds that ranged from about 2.4 to 3.1 miles per hour through those cameras.
And in relation to walking speed, how would we compare these two?
Several articles on the internet state that preferred walking speed for people is about 3.1 miles per hour.
So this particular vehicle is in range of human walking speed.
Yes, sir, that's accurate.
And were your results consistent with the results that Mr. Johnson came up with regard to his digital video analysis?
Yes, sir, the information I got from the wheel rotations was consistent with his photogrammetric analysis that he did.
Thank you, sir. Let me ask you, Mr. Brown. Partain, how much do you charge? What's your rate?
$215 an hour.
Okay, do you know approximately how many hours you spend on these different things?
I think it's about 25.
Okay.
It may vary there. I don't have the exact number.
Pass with me, Sean. Thank you.
Cross-examination.
Ms. Partain, it took you around 25 hours to do this calculation?
Yes, well, there were several tasks involved, but yes, ma'am.
Were you afraid during that time?
No, ma'am.
Were you under a stressful situation?
No, ma'am. Well, other than getting the right answer.
Were you worried? Yeah. Were you worried about yourself or other people?
As far as,
That somebody could get hurt if you got it wrong?
no, ma'am.
But it took you around 25 hours to gather all of this information, process it, and make sure you were right.
Well, you know, as I said, there were several tasks, and I look at it that I would rather have someone criticize me for spending too much time on analyzing a task rather than casually coming to a conclusion by not spending enough time on it. And I try to do my work as quickly as possible and be as accurate as possible in that time.
But you had the luxury of taking all the time you needed, didn't you?
Yes, ma'am.
And the amount of time it took to make sure that you get it right, it was around 25 hours.
Yes, ma'am.
Pass the witness.
Mr. Lewis,
No further question, John.
may this witness be finally excused.
No objection.
Thank you all very much. Sir, you're excused from your service. You may stand down. Call your next witness, please.
State calls Jonathan Priest.
Members of the jury, why don't you take a 10-minute recess in between these witnesses? So if you would, please, all rise for the jurors. Courts of business. 10 minutes.
Oh, I'm sorry.
Thank you, Sheriff. Y'all may be seated. Ms. Nicholson, call your roll.
This time, Your Honor, the state calls Mr. Jonathan Priest.
Sir, if you would please come to the front of the court. Swear you in front of you. If you could please raise your right hand. You swear the testimony you're about to give will be the truth.
I do.
Please have a seat. Respond to questions first, please. Perhaps after that, Ms. Matson or Mr. Harris. You may proceed whenever you're ready.
Thank you, Your Honor. Good morning, Mr. Priest. Would you please introduce yourself to the jury?
Certainly. My name is Jonathan Priest. That's JONATHYN PRIEST.
And Mr. Priest, what do you currently do for a living?
I'm a forensic analyst and educator for Bevel Gardner and Associates. Basically what that means is I look at cases, I analyze cases, and I instruct others in both criminal justice field, law enforcement attorneys, and colleges in the area of forensic analysis.
And Mr. Priest, prior to your current position, what was your previous career?
I was a police officer for the city and county of Denver in Colorado. I was there 32 years, spent time as a patrol officer, as a detective, as a sergeant, and as the commander at lieutenant rank for the major crime section.
And Mr. Priest, have you had an opportunity to investigate officer-involved shootings?
Many.
And please tell the jury about your background and experience in investigating officer-involved shootings.
When I was working for the Denver Police Department, I began working in the homicide unit in the late 1980s. As a detective in the homicide unit, one of our responsibilities, in addition to death investigation, is the investigation of officer-involved shootings. I was promoted to sergeant and again was assigned to the homicide unit, where we continued not only death investigations, but the investigation of officer-involved shooting. But as a supervisor, I had greater roles in the involvement in interviewing involved officers and witness officers, as well as policy creation in the area of officer-involved shooting investigations, both criminally and administratively. I was then promoted to lieutenant, where I became the commander of the major crime section, which included the homicide unit, among other criminal investigative units. And at that point became greatly involved in officer-involved shooting investigations, policy creation, and instruction in those areas.
And Mr. Priest, how many officer-involved shooting investigations have you conducted as the lead investigator?
Hundreds. Hundreds. Where an officer discharged their firearm, hundreds.
And so it's, I guess, fair to say too many to count?
Yes.
And Mr. Priest, would you please tell the jury what exactly is an officer-involved in shooting investigation?
Officer-involved shooting investigations predominantly relate to those incidents where a police officer discharges their firearm or a police officer is shot. Those typically are the cases that are related to anything that is classified as an officer-involved shooting.
And Mr. Priest, do you hold any special certificates or training when it comes to the field of officer-involved in shooting investigations?
Well, certainly have a background in crime scene investigation, both hundreds of hours of instruction, plus I teach in those areas of crime scene investigation, which relate directly to officer-involved shooting investigations. I have a background through the International Association of Identification in certain areas of analysis that may become relevant in officer-involved shooting cases. I also hold a certificate with the Force Science Institute, which deals specifically with dynamics related to officer-involved shootings.
And Mr. Priest, have you had an opportunity to testify as an expert when it comes to officer-involved shooting investigations?
Many times.
And have you in fact testified within the state of Texas?
I have.
In Dallas County?
Yes.
In this very courthouse?
Yes.
Have you had the opportunity to testify in other states?
Yes.
In federal cases?
I have.
And Mr. Priest, certainly you are hired, is that correct?
I am.
And what is your hourly rate?
My hourly rate is $175 an hour. That said, in full disclosure, my company charges $295 an hour. My rate is $175.
And do you have an estimate of how much you anticipate the final bill will be for your work involving this criminal prosecution?
And I certainly don't have a total amount. I would say, given the amount of material that I've reviewed in this, I'm probably looking at 30+ hours total.
And Mr. Priest, have you had an opportunity to review cases on behalf of the state before?
I have.
And have you reviewed cases on behalf of the defense before?
I have.
And what would you say, or do you have an estimate of what percentage of your work is spent working for the state and defense or any other agencies?
In criminal cases, I'm roughly about 60% of the time prosecution, 40% of the time defense. In civil cases, I'm probably half and half.
Now, Mr. Priest, when we asked you to take a look at this case, what exactly did we ask you to do?
It asked me to look at the case and determine, do it reasonableness inquiry.
Did we tell you any sort of opinions that we had regarding the defendant's use of force in this case?
No.
What information were you provided?
The entire case file. I looked at photographs, body-worn camera video, several documents related to training, agency policy and procedures, crime scene investigation information, and I got over probably 10,000 pages of documents, minutes of video and audio, photographs. I'd have to look at the entire list to determine exactly everything, but predominantly the investigative file.
Okay, and so would you say would it be a lot of material or very little material that you received?
It was a lot of material.
And Mr. Priest, did we in fact ask you to review this case and to render an opinion as to the defendant's use of force?
Yes,
And were you able to do that based on all the information that you've received?
I was.
And Mr. Priest, would you please share for the jury what exactly was your opinion?
My opinion in this case is that the use of force in this particular incident was unreasonable.
And Mr. Priest, what exactly do you, what formed the basis of that opinion? Would you please share that with the jury?
Two things major were the statutes of the state of Texas, predominantly Section 9, and the policies and general orders of the Dallas Police Department.
And when you say Section 9, you're talking about Chapter 9 of the Penal Code?
Correct.
And you stated the policies of the Dallas Police Department.
Yes.
Mr. Priest, why would the policies of an agency, or in your opinion, why does an agency have policies related to rules for their officers to follow?
Policies predominantly mirror what statutes say. It also is consistent with training protocols that the officers receive. So they're the policies, general orders, procedures, agencies call them different things, but they all pretty much mean the same thing, are the guidelines that officers follow when basically involved in any given particular incident. They call them general orders or procedures, mainly because they're not looking for something specific per se, but they're giving general guides for officers to follow when they're involved in any given incident.
And you stated that you, when rendering your opinion in this case, that you did make note of certain general orders and policies of the Dallas Police Department.
I did.
What specifically was of interest to you?
Predominantly the use of force general orders. I believe coincidentally that was also the 900 series.
And would that be Dallas Police Department General Order number 906?
Yes.
And in particular, 906.02, which is the use of deadly force policy.
Correct.
Now, let's go back to the beginning. When you look at a case before you render your opinion, do you start at what information was available to the officer?
Typically, when I analyze a case, I begin where the case began. I want to start with the crime scene. So I'm going to look at what was available to the officers at the scene, what information exists to put me into a position where I can make a inquiry into basically what the officer experienced.
And based upon your review on this case, what did you gather that this defendant knew either arriving to the scene or as the scene unfolded?
This case began as a suspicious vehicle. During the initial response to the scene, further information was developed, depending on what information existed, but that there were occupants in the vehicle, that the occupants were a male and female, that the occupants had been at that location previous, that the vehicle was listed as stolen. All of these things are available to the officers as they're approaching and would typically create a response for the officers and a process in how they will respond to that particular incident.
And based on the materials you reviewed and your understanding of the way that the Dallas Police Department trains its officers, did you make any note or consideration as the defendant's approach to the vehicle in question?
I did.
And please share that with the jury.
When the officers first arrived at the scene, their approach was certainly tactically sound. They maintained a position of cover, maintained a visual on the vehicle, allowed other officers to arrive, had some level of communication amongst each other as they're making a decision on what the ultimate approach might look like. Began to attempt contact with the individuals in the car, trying to make contact with them to get a response from the individuals in the car. There was discussion about was anybody actually in the car, and what should next steps be.
And you've had an opportunity, you sat throughout this entire trial and you were able to listen to all the testimony that's come forth today. But taking that into consideration, what do you make of the defense's decision to pull the squad car closer to Ms. Dawes' vehicle?
From a tactical standpoint, by moving forward, it reduced the amount of distance between the officers, and it also created a greater risk to the officers, simply in the fact that from their initial position where they were in a much better position to respond and develop additional options should that need arise.
And Mr. Priest, what does the expression closing the gap mean when it comes to law enforcement?
Closing the gap basically means getting closer, taking that distance cushion away and getting closer to them. There are situations where closing the gap can be advantageous. There are other situations where gaining distance is much more advantageous and less risky.
And what are the concepts of time, cover, and distance? And why are they important to police officers?
Time gives you time to assess, time to evaluate, time to discuss options, time to allow additional officers to respond should that be the particular setting that would need to occur. Time for additional lighting, say that's near dawn or something, or near dusk if darkness would be more advantageous. Distance gives you options. Distance gives you ability to not only assess with the time that you have created for yourself, but gives you time to react. Reaction time takes time, and distance allows for more options available to the officer. Tactics certainly relate directly to okay, should I have more time? Should I have greater distance? What options are available to me and how can I react given this particular situation?
Now, Mr. Priest, as we're walking through the encounter that had happened on January 18th, 2017, what next what did you notice next of importance?
Well, after the vehicle was moved closer to the subject vehicle, officers moved closer, reducing their distance and their ability to respond. Two of the officers actually moved into a position where they were relatively directly behind the car, in a position where they don't really have any cover at all. And it was just kind of an interesting observation in that while everybody is moving behind a vehicle, based on the information, the purpose of moving the car up was to provide close cover. Two of the officers didn't even use the close cover.
And is it your understanding of the policy of the Dallas Police Department when it comes to moving vehicles, are officers authorized to use deadly force in those situations?
In a moving vehicle?
Yes.
No.
And what is the danger of using deadly force in a moving vehicle?
Well, a vehicle is a machine. The machine is operated by an individual. If fire is delivered to that machine and it takes out the individual operating that machine, the machine can become more dangerous than it initially was because now there's nobody operating it. It's just an unoperated machine. So that's one problem. A second problem is that we don't know who's in that vehicle. And certainly the person operating the machine doesn't necessarily speak for or represent any other individual that might be in that vehicle. So they are placing not only themselves in danger, but others who may be in the vehicle in danger. Additionally, who's around the vehicle, whether seen or unseen. Shooting at any moving target is difficult. Even through training, it's difficult. And the danger in causing unexpected or unwanted collateral damage is raised by the fact that you are now engaging with deadly force, something that is in motion.
And Mr. Priest, what next did you notice in the incident that occurred?
The vehicle began to move. And as it moves, the police car is then moved forward in, for all intents and purposes, a barricade setting being used to block the car in. And the subject vehicle backed into the police car. There was contact. Officers see this car moving and, consistent with agency policy, began to move to better positions of cover, or certainly out of the way of the direct path of the vehicle. The vehicle then moved forward towards the fence. It made contact with the fence. There was an audible noise of contact. Officers continued to move to different positions. The vehicle then reversed a second time. The front steer wheels of the vehicle turned to allow it to miss the police vehicle, which was obviously parked behind it, and began to move in a straight line along the front of the police vehicle. It was at that point that shots were heard.
And Mr. Priest, can you explain to the jury, based on not only the Dallas Police Department's policy, but best practices for law enforcement, how are officers trained of things that they should look out for when they actually use their firearm?
Well, there's 4 rules of firearm safety that are trained with not only law enforcement, but people who take shooting classes in general. And the first rule is that all firearms are always loaded. The second rule is that keep your trigger or keep your finger off the trigger until you're on target and ready to fire. Don't let the muzzle of your firearm cross or point at anything that you're not willing to destroy. And lastly, be aware of your target and what lies beyond. Anyone who is discharging a firearm needs to be aware of those 4 rules. Officers not only are taught that routinely, but many training academies have them posted in many locations, both at the training facility and around law enforcement agencies.
And based upon the Dallas Police Department's policy as well as best practices for law enforcement, did the defendant's action in firing his firearm follow that training?
Certainly the officer was aware of trigger control. All fire was directed at the target that he had identified. There was no information that I had from a review that he was unaware that his firearm was loaded. He obviously allowed his muzzle to cross a target. The big thing was aware of the target and what lied beyond. I found nothing in the material that I reviewed that any officer was aware of what lied beyond their target.
And with any of the material reviewed, were you aware of any officer actually knowing who was inside that vehicle?
No.
What they were shooting at inside the vehicle?
No.
Does the Dallas Police Department train its officers to shoot blindly at vehicles?
No.
What would have been the actual target?
Well, based on the information that I reviewed, the driver of the vehicle was the target. But again, that information was not determined to a level of completeness. I found nothing in the material that I reviewed to where questions were asked of anyone to support exactly what the point of aim was.
Were the officers able to identify or see who was inside of that car prior to shots being fired?
No.
And in your review of the material, it listed in fact that at the moment that the defendant shot out the passenger window that they were able to see inside the car.
Well, even then, once the window is broken, we're pretty much towards the end of the incident. But even then, identifying specific individuals or an individual inside that vehicle was certainly not determined based on the materials that I reviewed.
Mr. Priest, at this time, I want to show you what's been entered into evidence as State's Exhibit number 140.
North Washington, this black male refused to stay away from property.
Silence! Now! Silence! Watch out. Back up.
Have you around the like security their uniform and armed?
Don't move!
Okay, and we paused the video right as the first shot is being fired, but if we go directly just before that moment, Mr. Priest, are there any officers that are standing behind that Dodge Journey?
At the moment shots are fired?
Before the moment that shots are even fired?
Oh, well, depends on how far before the moment. I mean, obviously there are officers behind the vehicle, but when we get into a position or the vehicle gets into a position where shots are fired, no officers are back there.
All right, and we're going to start it up again.
Watch out. Back up.
Have you around the like security
And so at this point in time, as before the vehicle even backs up and before the defendant fires shots, there are no officers that are standing behind that Dodge Journey. Would you agree with that?
That's fair, I'd agree.
uniform and armed.
Don't move! Hands up! So push!
So we have 2 volleys of shots in this incident. How do you characterize the second volley?
The only thing that I can assess just by looking at that information is the second volley was shot simply because the car was rolling. There was no assessment of the information that I saw that there was a reanalysis by shooting officers of any danger to anyone at that point.
And are officers trained to reassess situations if situations can change over time? Are they taught to kind of pause and reassess what's going on?
Reassessing is a big part of discharging a firearm, being aware of your target, what lies beyond.
Are officers trained to shoot at vehicles just because they're continuing to move?
Officers are not trained to shoot at vehicles at all in typical situations.
Are officers trained to shoot when it comes to deadly force just because someone disobeyed a verbal command?
No.
Are officers trained to shoot if there has been no specific, I guess, articulation of deadly force being used by the individual that they're shooting at?
No.
Based on your assessment of this case, was the vehicle moving in reverse a threat to any of those officers, a deadly force, immediate at that point in time?
At the moment shots were fired, there was no immediate need to use deadly force.
Mr. Priest, I believe that you were also in court last week and we heard from one of the defense experts, and he talked a lot about how officers are trained, but that under certain situations that they're human and they just can't comport with that training. What do you make of that characterization or that line of testimony for the defense expert?
Well, it's inconsistent with training. It's certainly inconsistent with my experience.
Why do officers train?
Officer training is basically designed to improve a response to any given situation. Many of us experienced that the first time we ever drove a car. We would probably admit that the first time we drive a car, we're not as good as we may be after several years of driving a car, or doing anything for that matter. Painting or even sweeping a broom, using something. You get better as you begin to learn how the thing actually works. Stressful situations, however, incorporate a number of other things that come into play. And training is designed to reduce reduce not only your trait anxiety, but your state anxiety. Probably should explain that.
What is the difference between state and anxiety?
Okay, trait anxiety is the anxiety that any given individual has routinely. Different things may affect you differently than others. There are people who are afraid of spiders. There are people who are afraid of snakes. There are people who are afraid of any number of things, loud noises, quiet, dark, light. Any number of things come into play, and that's trait anxiety, and those things stress you. State anxiety is the anxiety that you experience at a given moment. You're driving down the road, and in Texas, when rain freezes on the road, you may lose control of that car. And that can create state anxiety. And depending on your skill level, your training, your background, your experience, how you respond to that can differ. However, training in stressful situations can reduce certainly state anxiety, that you're able to respond better to a given incident because of that training, and it can also have an impact on, because of repetition, your trait anxiety. You're able to control it better. even though you may still be afraid of spiders, you have an ability to deal with it because you recognize that I know I'm afraid of it, but I have to deal with it, so I do, and that can be trained.
And Mr. Priest, in your review of the materials, has the defendant received many hours of training?
I believe the material that I reviewed, over 1,000.
Over 1,000.
Yes.
And is the defendant, would you classify him as a rookie officer, or he had been on the force for at least a number of years?
The material that I reviewed supported that the individual had been on the aid to the department for over 10 years. Over 1,000 hours worth of training, that's significant. That's a lot of training.
And Mr. Priest, based on your review of this case, did you find any connection between the gun that was later found inside of the Dodge Journey and the defendant's decision to use deadly force?
No.
So no connection between the two at all?
None.
Mr. Priest, what is tunnel vision?
Tunnel vision is hyper-focus. Our eyes have the ability to see certain things. We have both our focal vision, and that's what we're paying attention to, and we have our peripheral vision. The human eye, a single eye, has the ability to have about 130 to 134 degrees of peripheral vision. But our focal vision is pretty finite. It's very distinct, and that's only about 2 to 4 degrees. If you were to take your thumb and put it out in front of your face and stare at your thumb, that's about the width of our focal length. And everything else around it gets a little out of focus. In stressful situations, what happens with the body, because it's interested in preservation, we go into a response, typically a sympathetic response, typically known as fight, flight, or freeze. Any stressful situation, we may experience that. And when that occurs, our hyper-focus starts to really pay attention to what we may identify as a threat or identify as a concern. We really begin to hyper-focus on that, and that peripheral vision really starts to take a back seat. And it's not like it disappears and becomes this dark tunnel, but it's not something that our mind is capturing and remembering. That's basically tunnel vision.
And specifically, as applied to this case, do you have an example that you can give the jury of how tunnel vision could come into play with regard to the Dodge Journey moving?
Well, certainly, and with respect to how tunnel vision can be trained out,
Yes.
certainly. If you were to take, for example, say a football game, you look at the quarterback, who obviously and arguably is in a stressful situation. Why? Well, there's stress to succeed. There's stress to make sure that you do, in a passing situation, stress to get the ball where you need it to go. You need to be paying attention not only to getting the ball downfield and to the target that you're getting it to, but you also have to be aware that there are several individuals that are going to try to get to you and stop you, and you need to be aware of them. So training comes into play to where as they're moving at you, I'm paying attention to them so I can move if I need to. I can reduce the risk of losing the ball to those individuals, still maintaining my focus on the individual that I want to get the ball to. All of these things are training situations where I can improve my response given my background in training and the level of stress that is actually being applied to me.
And as a police officer, for police officers, does tunnel vision cause you to lose focus of the target or your background or what else may be lying beyond the field of where that officer is firing?
Depending on the level of training of the particular individual and depending on the circumstances, certainly tunnel vision has an effect. It is certainly something that can come into play. But again, one of the reasons that we try to reduce tunnel vision, or one of the ways that we try to reduce tunnel vision, is through that training. Because we recognize that it is a factor. And through additional training, through providing examples or experience to officers in non-stressful situations, it helps them reduce that particular tunnel vision setting. Your background in vision doesn't actually go away. Your ability to report it might, depending on how much of an effect it has on that particular individual.
And in this particular case, with review of the material, do you recall in the body-worn cams where the defendant is telling other officers to get back, get back?
Oh, definitely.
And then does tunnel vision, I guess, is it kind of like a trance where an officer just forgets about everything else that's around them?
From a memory standpoint, people have an inability to report what they don't perceive, meaning that you can't talk about things that you just don't encode. You don't perceive it, so you can't talk about it. That's part of tunnel vision. To completely ignore those things, depending on your level of training and background and prior experience, it becomes less likely for the individual trained in certain circumstances to have the same effects as somebody that doesn't have the same background and training.
Mr. Priest, what is sympathetic fire?
Sympathetic fire, the nervous system, you have two different areas of concern. One is the somatic system. Somatic system is the voluntary system. I can pick this pen up, I can scratch my cheek, I can run my hand through my hair. These are all voluntary responses. The sympathetic system is a subset of the autonomic system, which means things are done unconsciously or unintentionally. And that breaks down into two different areas, the sympathetic and the parasympathetic. The parasympathetic system is that maintains homeostasis. It reduces our heart rate and blood pressure, it improves and increases digestion, it creates a relaxing atmosphere. And sympathetic, and we've talked a little about this already, is that fight, flight, or freeze response to where a number of things can occur. Sympathetic fire the sympathetic reactions can be a reaction to stress. We often see it if you've ever watched a scary movie and something scary occurs and you startle and you jump, that is a sympathetic response. There's no actual threat to you, but your body can't differentiate. Your body can't differentiate between something real and something perceived. So the fact that you're actually being threatened, the body doesn't know. All it does is perceive, the body just sees that and reacts to it. So that's that sympathetic response. And in sympathetic response, a number of things can occur. You can just tighten up, that's freeze, okay, where you're just tightening up like this. You can jump, you can fall down, you can scream. A number of different things can occur in those areas as well from sympathetic response. And it's just a reaction that the body has, and it's a non-voluntary or autonomic response.
So a simple way for you of phrasing it is kind of like you just reacted to whatever it was, maybe something startling occurred, and you just reacted.
Sure.
Did you have any opinions when reviewing this case regarding Officer Kimple's firing his firearm?
I did.
Please share that with the jury.
I'm going to object, but Officer Kimble has testified why he fired the firearm. He is the best position to tell this jury that. This expert has no reason to have an expert opinion on what Officer Kimble was thinking when he's already told the jury.
And Judge, if if I may, and this witness certainly isn't going to state to what was in Officer Kimball's mind, but furthermore, this witness is going to state that as part of his consideration or his ultimate opinion, he did take into account the fact that Officer Kimball did fire his firearm as well. Thank you, Your Honor. Mr. Priest, I believe you were getting ready to share with the jury what were your opinion that you had regarding Officer Kimball firing his firearm.
Officer Kemple fired a single round. Law enforcement routinely and nationally doesn't typically train officers to fire a single round. Most training regiment goes through firing twice, firing 3 times, reload drills, firing additional times, but from a training standpoint, firing a single round is unusual. Based on my experience, based on the investigations that I have conducted over hundreds of officer-involved shooting situations, when an officer discharges a single round, that typically speaks to sympathetic fire rather than intentional fire.
I'll ask the witness.
You never interviewed Officer Kimball, did you?
No,
You never asked him, did you?
no,
You never talked to him, did you?
no.
You didn't check your findings, did you?
I'm sorry, say that again?
You didn't check this opinion with the actual source before you decided you're an expert in front of this jury. You didn't even talk to him, did you?
I did not talk to Officer Kemple, no.
You just decided that you know better than every officer out there without interviewing a single one, correct?
No, I never said anything about knowing better. I'm simply speaking to my experience in investigating hundreds of these types of cases.
Without interviewing a single witness.
That's true.
Anything further?
Nothing further for this witness, Your Honor.
Sir, you may excuse me further disturbance unless there's an objection.
No objection on the state.
Ms. Manson. Very good. Call your next witness, please.
Your Honor, ladies and gentlemen, jury, the same risk.
It's customary in our law and our procedure to take a break at this time, so if you would please go with the sheriff to await further instructions. All rise, please, jurors. Thank you, Sheriff. Y'all may be seated. What you intend to do, I want to give you an opportunity to dig into before we call the jury back. I don't know if you call the client, if you may be reviewing the admonitions, however you want to proceed. And that includes taking a break to discuss.
I'll just need a short break. I think we made our decision.
Course and recess. Five minutes. team has had an opportunity to speak with their client about his decision to testify or not. They've come back in court, let me know they're ready to go. Ms. Mattson, is there anything you want to put on the record at this point?
Yes, Your Honor, I'd like to call my client for the limited purposes of this hearing.
Sir, if you could please raise your right hand.
Yes, sir.
You swear the testimony that you're about to give will be the truth.
Yes, sir.
Put your hand down. Go ahead, Ms. Mattson.
Mr. Hess, I have gone over the fact that it is your right to testify, and that right belongs to you and you alone, correct?
Yes, ma'am.
And that it is a decision you make, but that you can rely on my advice or not, correct?
Yes, ma'am.
And I have told you that I believe that the state has failed to meet their burden, and that I do not believe that you need to testify. However, I have told you that this decision will belong to you and you alone.
Yes, ma'am.
Are you going to testify?
No, I'm not.
Mr. Hess, do you have any questions for me?
No, sir, I do not.
Okay. Is there anything else that we need to put on the record at this point in time?
No, Your Honor.
Are you having trouble locating any other witnesses or anything like that?
No, Your Honor.
Okay. Then let's take a recess. The record should reflect we're going to discuss the jury charge off the record. That we will hopefully have a jury charge ready soon. So that's it. Court's in recess. Let me see all the lawyers. request by the defense for apparent danger to be included in the charge. Mr. Fishburne?
We request apparent danger be included in the charge because it is on this jurisdiction. And parties are going to be able to argue whether it was reasonable to apprehend the danger, and the jury needs to know about that.
Okay, Mr. Gladden?
Judge, the language of apparent danger proposed by Mr. Fishburne is not the law. Under the penal code, the case law doctrine that a person can defend himself against an attack that he believes to exist, just as much as a real attack, has been held by the courts to be encapsulated in the statutory definition of reasonable belief, and that the Court of Criminal Appeals and the Dallas Court of Appeals, this jurisdiction, have said that that is the appropriate charge for a justification based upon reasonable belief.
Well, they've said that's adequate, and we believe it is inadequate, and we would request it go in.
And the specific request that I have before me is you're wishing to use this language. An individual has a right to defend himself from apparent danger to the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him at that time.
Yes, for self-defense, and then another one for defense of a third person with that added to it.
All right, and I'm going to overrule your objection, but I agree that that is an argument that can be made. It just can't be contained in the jury charge according to our Court of Criminal Appeals and to the Dallas courts, in my opinion. So parties can argue it. It's a valid form of argument, but it's just not in the jury charge. It's, to me, a definition of what's reasonable. So number 2 is the request by the defense that the mental state of reckless should be out of the jury charge. Mr. Fishburne?
There is no evidence in this case that the defendant acted with the culpable mental state of reckless. He saw the threat, he sighted the target, he hit the target intentionally or knowing that it would likely cause the result. There was nothing reckless about what Officer Hess did.
Any reply?
Yes, Judge, the evidence shows that the windows were fogged up, the officers could not see into the car. Officer Hess could not sight his target. He shot a gun into a car that he at best knew was occupied because it was being run. That's being aware of and consciously disregarding a substantial risk that bodily injury will occur to a person in the car. There's plenty of evidence in this case about his training, about the use of firearms with sighting his target, being aware of his background, and the fact that he could not see into the car when he made the shot. So the issue of recklessness has been raised by the evidence, and in addition, it's in the indictment, and it's what he pled not guilty to. So issue is joined on that allegation.
It is not joined, and it is not in the case. He shot 12 times, did not shoot the last time because the threat was stopped, and he hit his target 5 times, twice in the neck, once in the shoulder, and twice in the arm. There was nothing reckless about it.
Okay. The objection's overruled. Next up is the state is requesting self-defense not be in the charge, if I understood correctly.
That's correct, Judge.
Go ahead.
The state's argument is that for a defendant to be entitled to an instruction on a defensive issue, there must be some evidence that would raise every element of the defensive issue. The elements of self-defense are a belief that force, when and to the degree used, was immediately necessary to protect himself against force. A belief that deadly force, when and to the degree used, was immediately necessary to protect himself against the use of deadly force, and that those two beliefs be reasonable. That is, that those beliefs be held by an ordinary and prudent person in the same circumstances. I've been sitting in this entire trial taking copious notes. There is no evidence in this trial that the defendant believed that Genevive Dawes was using deadly force against him. There is the video showing some evidence that he believed the car might have hit the other 2 officers, but there is no evidence that at the time he shot, the defendant believed that any deadly force was being used against himself. And so there is no evidence to raise that defense at all. We're not talking about incredible evidence or contradicted evidence or impeached evidence. we're talking about no evidence of what he believed about the use of deadly force against himself. And so it hasn't raised the issue of self-defense.
Mr. Fishburne, what do you think?
There's ample evidence. First of all, he's got to be justified to defend himself before he can defend somebody else.
That's not quite right.
Well,
It's right enough on the facts of this case. The car was backing toward him. He perceived the threat. He also perceived the threat to the other officers. And I would submit he perceived a threat, deadly threat, to all of the officers that were present, not just Kimball and not just Hopkins. And there's ample evidence. There is at least a scintilla of evidence raised in this case to authorize the jury to decide for themselves whether or not he was justified in using deadly force to defend himself from a deadly attack.
Okay. Mr. Gladden, go ahead. You wanted to say something.
Sure, Judge. Two things. One, there's certainly evidence that officers on the scene believe that that car might be turned and directed toward them in the future. But self-defense requires a belief that it be immediately necessary when used and to the degree used. So we have that contemporaneity requirement. You can't defend yourself against what you think might happen even 5-10 seconds down the road if 3 other intervening circumstances occur that you don't actually know will happen. At the moment he used force, the car was turned and backing away from him. There is no testimony that he perceived any threat to himself when he used deadly force. And then the second response is self-defense is not required for the defendant for him to claim defense of others. The defense of others statute requires him to believe the circumstances to be such that if he were in the position of the others, he would be able to use self-defense. In other words, he has to reasonably believe that those others could have used deadly force. That's putting the defendant, as alleged, behind the Dodge journey, not by the squad car, where there is, again, no evidence of any threat being directed in that direction at the time the shots were fired.
He is parsing the facts too finely. It's a fluid situation. It occurs very quickly. Mr. Gladden's position would be, well, let's see if he's going to get run over or not. Maybe when the wheel rolls over his foot, he can shoot then.
Okay.
We submit that it's in there.
All right. I do find that there is some evidence to support the inclusion of self-defense as well as defense of a third person. So I'm going to overrule your objection, Mr. Gladden, and include the charge of self-defense as well as third person in there. There was also this objection by the state about, I believe it was by the state, about including deadly force to effect an arrest, essentially. You want to articulate that for the record, please?
Yes, Judge. Same standard applies. There has to be some evidence raising every element of a defense for it to be submitted to the jury. And the elements of deadly force by a peace officer making an arrest are, you have to have a peace officer. He has to reasonably believe that deadly force, when and to the degree used, is immediately necessary to make an arrest. So you have to have a belief that's reasonable. He has to reasonably believe that the arrest was lawful. So you have to, again, have a belief that was reasonable about an arrest that was lawful. And then there are the elements of, before using deadly force, he has to either manifest his purpose and identify himself, or believe his purpose is known or can't be made known, and reasonably believe that the conduct for which arrest was authorized included the attempted use of deadly force, or there's a substantial risk of death or serious bodily injury to himself or another if the arrest were delayed. Certainly there's been a lot of evidence in this trial that the defendant was a peace officer at the time. Certainly there's been a lot of evidence in this trial that other officers on the scene believed that if the defendant did not shoot into that car at that moment, that there was a substantial risk that the car would turn around and drive towards the officers. But what there is no evidence of here is what the defendant believed with respect to an arrest. The defendant said he thought the car was about to strike Hopkins and Kimball. That's it. That's the only evidence we have of what the defendant believed. The defendant never told anyone that he was arresting anybody. The only evidence in this trial in which the word arrest was used was from Officer Ailish's testimony that he believed he was arresting the people in the car for unauthorized use of a motor vehicle, but then what he said was that he was going to get them out of the car to investigate whether the vehicle was stolen. That's not an arrest. That's an investigative detention. And the facts that Officer Ailish based that on are not legally sufficient to justify an arrest. If Ailish had gotten the two people out of the car at gunpoint and arrested them for having a stolen car at that point, that arrest would not be supported by probable cause, because all he had at that point was a report that the vehicle was stolen. He had no identifiable facts about whether there was effective consent to use the vehicle or who was even using the vehicle when he made the decision to detain the people. But all that's in Officer Ailish's head. We don't have any evidence of what's in Officer Hess's head. And so there is no evidence in this case that the defendant believed he was making an arrest, much less that the arrest was lawful at all.
Mr. Fishburne?
The Officer Hess's belief is evidenced by the surrounding circumstances of this event. The complaining witness's conduct was arrestable when she started driving toward the officers, when she started driving through the fence. There is ample evidence that those people were going to be arrested as soon as they got them out of the car for the stolen vehicle. You had officers conducting a felony stop. They were there on a report of a stolen vehicle. There were repeated refusals to adhere to the lawful commands of the police, and to argue that there was no basis for an arrest immediately is incorrect on the facts. And then to argue that there was no basis for the arrest based on Ms. Dawes' conduct with the car and the likelihood that the arrest would have been delayed and they let her go careening down that alley, she wouldn't have hit somebody else. So this is among the facts of the case and should be submitted to the jury. Let them decide.
All right. The state's objection is overruled. There is the request to have certain terms unbolded by the defense. I'm going to overrule your objection. There's a request by the defense to have included in the charge from the Code of Criminal Procedure the duty of a peace officer.
Yes, sir.
And I want to read that real quick. Maybe. Okay. What I have submitted by Mr. Fishburne is the following language. It is the duty of every peace officer to preserve the peace within the officer's jurisdiction. To effect this purpose, the officer shall use all lawful means. Mr. Gladden, do you have an objection to this?
Yes, Judge, multiple objections.
I'll probably only need one. Let's do them one at a
Certainly.
time.
Well, I'll make one objection with multiple supporting theories. I don't know how else to word it. The jury charge has to contain the law applicable to the case, instruct the jury on how to analyze the facts of the case, and avoid confusion. That is the purpose of a jury charge. Here, the definition of duties of peace officers from the Code of Criminal Procedure doesn't fit into any of those categories. It doesn't tell the jury the law applicable to the case because what it says is that peace officers have a duty to use lawful means. Whether the defendant in this case as a peace officer used lawful means is a fact question for the jury in this case. So to tell the jury that he had a duty to follow the law when that's not an element of a defense, it's not an element of an offense, doesn't give the jury any guidance. And it potentially confuses the jury about what we're actually deciding here.
All right. Mr. Fishburne?
It puts the jury in the position to put Officer Hess in context with all the other officers so they know what their duties are as they go out there. Their duty is to lawfully discharge the application of the laws.
Okay.
And that's all it is. It's just explanatory in its background and its context in which we're operating.
All right. Your request is denied. Next up, we've got a request by the defense to have certain language included that is as follows. Now bearing in mind these instructions, if you unanimously find the state did not disprove Officer Hess was justified in using deadly force to make an arrest beyond a reasonable doubt, or if you have a reasonable doubt whether the state disproved Officer Hess was justified in using deadly force to make an arrest, you will find Officer Hess not guilty. It's my understanding that Mr. Gladden had some objections to this language. Mr. Gladden?
Yes, Judge. I believe that the penal code, in talking about defenses, says that if the issue of the defense is raised, the court shall instruct the jury that a reasonable doubt on the issue of justification requires that the defendant be acquitted. That's what the code provides for. And that's what this court has put in the charge on page 4, where it says a defense to prosecution. It is a defense to prosecution that the conduct in question was justified. You are instructed that a reasonable doubt on the issue of justification requires that the defendant be acquitted. Anything beyond that is more than what the code provides for. It's not the statute, and it's not appropriate for the jury charge, which again is to tell the jury what the law is, show them how to apply it to the facts, and to avoid confusion.
Mr. Fishman?
The purpose of the jury charge is to guide the jury clearly in their application of the law to the facts. A instruction that you read into the record in the active voice clearly demonstrates to the jury how they're to handle the elements of justification as to the burden of persuasion, and we requested it be in there.
I believe that the charge as written adequately explains the law and clearly does so. Your objection is overruled. Finally, we have, I believe it's finally, and I'll ask y'all if you have any other ones, but there's a series of instructions that are at the end of the jury charge. Instruction is not the right word. Forms, maybe. One of them says, ask the jurors to request, all of the evidence that was admitted. It's my common practice, I think in every trial I've done, just to, with the consent of the parties, to send all of the evidence back as soon as they deliberate, as soon as they begin their deliberations. I plan on doing that again in this trial. So that would make that form needless in my mind. So I'm going to take it out. Any problem with that, Mr. Gladden?
I don't have any problem, Judge, except on the final page of the jury charge itself, which is page 11, the top paragraph only talks about that form. So if the form is removed, it would render that paragraph superfluous. So during your deliberations, you are entitled to view any or all exhibits admitted as evidence in this case. A suitable form for requesting such evidence is attached to this charge after the verdict form. I think it's probably still fair to tell the jury they're entitled to view all the evidence, but if the court's going to send it all back and not have the form, I guess we take out the sentence telling them that there's a form.
Okay. Now, I'll do that, and while I'm doing that, is there anything else from the state?
No, Judge.
And is there anything else from Mr. Fishburne?
Yes, Your Honor.
Okay.
On page 5, right above where it starts off deadly force in defense of a third person, I'm referring to the paragraph above that. It would be called the sequencing instruction, and I object to the way that is written as incomplete. I submit that it should read, if you do not so find and you do not have a reasonable doubt thereof, or you have reached no decision, you will next consider defense of a third person, justification of deadly force in defense of a third person.
I think reaching no decision is the exact same thing as not finding.
It is.
It would be redundant.
It allows the jury to consider the jury charge in any order they want, which is the law, and it doesn't confine them. So if they get back there and they, for example, say, we're not sure about self-defense, and they're having trouble coming to any sort of an agreement, that instruction allows them to move on to defense of a third person without first making a decision on self-defense.
So you wanted to read, if you do not so find, and then what?
And
this wasn't one that we talked about. Go ahead.
no, and if you do not so find, or you have and you do not have a reasonable doubt thereof, comma, or you have reached no decision, you will or you may Next, consider the justification of deadly force in defense of a third person. It allows them to skip around in the jury charge.
All right, there's, your request is denied. Is there anything else?
Yes.
Okay.
The same request on page 6, the sequencing paragraph between defense of a third person and deadly force by a peace officer making an arrest.
Same response.
All right, the objection is overruled.
And I have one more thing.
Okay.
There is no duty to retreat when you defend a third person. I request that that be put in there on page 6, as it was earlier in the charge, after.
No, Judge, that's
Two.
not, that is not correct. 951 says there is no duty to retreat before using force as a peace officer making an arrest. The defensive third person statute says that if the circumstances are such that you, as you reasonably believe them to be, you would have been justified in using deadly force to protect yourself. So that refers into the justification of self-defense, which has the no duty to retreat language if the certain conditions are met. If you look up Penal Code 933, there is no sentence that says there is no duty to retreat before using force as described by this section. That's not in there.
If it's immediately necessary to defend a third person, the law can't be that I've got to retreat before I do so. And I request that that be in there for that reason.
And that is adequately covered by the statutory language. If the defendant reasonably believed that his intervention was immediately necessary, whether he reasonably believed that, A, whether he believed it, B, whether it's reasonable, is a fact question for the jury. To add something that's not in the statute is at best a comment on the evidence, and at worst, not the correct statement of law.
It is a correct statement of the law, and you can't have the jury back there arguing about whether or not Officer Hess had a duty to retreat before he defended Hopkins or Kemble, because he didn't. It's immediately necessary. Imminent means I must act right now with this amount of force. There is no time to retreat in defense of a third person. It's like that, and a split-second decision has to be made.
I'll agree to that if Mr. Fishburne can show me where in section 9.33 that is at.
Doesn't have to be in there. It's the law of defense of a third person. The law is it has to be imminently necessary in a split second to step in and intervene to protect that person. There is no duty to retreat.
All right, hold on just a second. All right, the request is denied. Morales versus the state, 357 Southwest 3rd 1.
That's the case I was thinking.
There you go. Court of Criminal Appeals. Okay. Are there any other requests that you have? Mr. Gladden?
No, Judge.
Okay, then let me go off the record. I'm going to print the jury charge. I want to talk to the lawyers. Mr. Prosper, Ms. Manson, we're off the record.
All rise.
Thank you, Sheriff. You all may be seated. Mr. Lewis and Ms. Matson, it's my understanding both sides have rested and closed. Is that right?
Yes, sir.
Very good. Thank you. You all may be seated. Members of the jury, as we talked about during jury selection and perhaps alluded to at some point during this process, after you hear all of the evidence that you're going to hear in this case, then the next thing that will happen is that I will deliver to you the jury charge. The law requires that I read it word for word. You will have this copy to take back with you during your deliberations. It does contain all of the law that is necessary to enable you to reach a verdict. You will see that the structure of the jury charge is basically, it contains the charge, contains some applicable law, those definitions, those terms of art that we heard in jury selection, that we've heard throughout this trial. If a word is not defined in our law, then you use your common, ordinary understanding of that word. Do not, under any circumstances, appeal to another source of authority, a dictionary, a Google, or anything like that. You're not supposed to have or be looking at any of those things during deliberations. The jury charge is approximately 11 pages. On page 12 contains the verdict form. The verdicts are mutually exclusive. And then there is a note form for you to use if you need to communicate with the court, as well as a request for testimony to read back to you. I'll get to that at the end. Jury charge reads as follows. Cause number F1700545, the State of Texas versus Christopher Hess. Members of the jury. The defendant, Christopher Hess, stands charged by indictment with the offense of aggravated assault by a public servant, alleged to have been committed on or about January the 18th of 2017 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. Your verdict must be by a unanimous vote of all members of the jury. In deliberating this case, you shall consider these written instructions as a whole, and you must not refer to, consider, or discuss any matters not in evidence before you. Do not let bias, sympathy, or prejudice play any part in your deliberation. Applicable law. Number 1. Person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault if the person commits assault and the person, 1, causes serious bodily injury to another, or uses or exhibits a deadly weapon during the commission of the assault. A person commits the offense of aggravated assault by a public servant if the person commits aggravated assault and the offense is committed by a public servant acting under color of the servant's office or employment. Page 2. 1.1 Definitions. You are instructed that, as used in the law applicable to this case, the following terms have the following definitions. Person means an individual. An individual means a human being who is alive. Another means a person other than the actor. Actor means a person whose criminal responsibility is in issue in a criminal action. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A deadly weapon is a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Public servant means a person elected, selected, appointed employee, or otherwise designated as an officer, employee, or agent of government. Government means the state of Texas, a county, a municipality, or political subdivision of the state of Texas, or any branch or agency of the state, a county, municipality, or political subdivision. 1.2 Mental state definitions. A person acts intentionally with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly with respect to the result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Page 3. A person acts recklessly with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary and prudent person would exercise under all the circumstances as viewed from the actor's standpoint. Number 2, application, charged offense. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about January the 18th, 2017 in Dallas County, Texas, number 1, Christopher Hess, hereinafter called the defendant, intentionally, knowingly, or recklessly caused bodily injury to another, namely Genevive Dawes, hereinafter called complainant, by shooting the complainant with a firearm, a deadly weapon. 2, and the defendant either A, caused serious bodily injury to the complainant, or B, used or exhibited a deadly weapon, namely a firearm, during the commission of the assault. And 3, the defendant was then and there a public servant, namely a City of Dallas police officer acting under color of his office and employment, then you will have found that the defendant committed the offense of aggravated assault by a public servant as charged in the indictment, and you will next consider whether the defendant's conduct was justified as explained below. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant not guilty and say so on the verdict form. Number 3, justification. If you have unanimously found beyond a reasonable doubt that the defendant committed the offense of aggravated assault by a public servant, you must next consider, page 4, whether the defendant's conduct was justified as 1, deadly force in self-defense, 2, deadly force in defense of a third person, or 3, deadly force by a peace officer making an arrest. It is a defense to prosecution that the conduct in question was justified. You are instructed that a reasonable doubt on the issue of justification requires that the defendant be acquitted. The defendant is not required to prove that his conduct was justified. Rather, the state must prove beyond a reasonable doubt that the justification does not apply to the defendant's conduct. In addition to the definitions already given, the following definitions apply to the issue of justification. Number 1, reasonable belief means a belief that would be held by an ordinary and prudent man in the same circumstances as the actor. Deadly force means force that is intended or known by the actor to cause, or in the manner of its use or its intended use is capable of causing death or serious bodily injury. Unlawful means criminal or tortious, or both, and includes what would be criminal or tortious, but for a defense not amount to justification or privilege. The term peace officer includes a police officer of an incorporated city, town, or village. 3.1, deadly force in self-defense. A person is justified in using deadly force against another. Number 1, if the actor would be justified in using force against the other, and 2, when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful deadly force. Page 5. A person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. A person who has a right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force as described by this section, and you may not consider whether such a person failed to retreat in determining whether the actor reasonably believed that the use of deadly force was necessary. Now, bearing in mind all the foregoing definitions and instructions, if you unanimously find from the evidence beyond a reasonable doubt that the defendant committed aggravated assault by a public servant as charged in the indictment, but you further find from the evidence, or have a reasonable doubt thereof, that 1, the defendant reasonably believed the force, when and to the degree used, was immediately necessary to protect himself against the use or attempted use of unlawful force by Genevive Dawes, and 2, the defendant reasonably believed that deadly force, when and to the degree used, was immediately necessary to protect himself against the use or attempted use of unlawful deadly force by Genevieve Dawes, then you will find the defendant not guilty, and so say on your verdict form. If you do not so find, and you do not have a reasonable doubt thereof, you will reject the justification of deadly force in self-defense, and you will next consider the justification of deadly force in defense of a third person. 3.2, deadly force in defense of a third person. A person is justified in using deadly force against another to protect a third person if, 1, under the circumstances, as the actor reasonably believes them to be, the actor would be justified in using deadly force to protect himself against, page 6, the unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect, and 2, the actor reasonably believes that his intervention is immediately necessary to protect the third person. Now, bearing in mind all the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that the defendant committed aggravated assault by a public servant as charged in the indictment, but you further find from the evidence or have a reasonable doubt thereof that 1, under the circumstances as the defendant reasonably believed them to be, the defendant would have been justified in using deadly force to protect himself against the use or attempted use of unlawful deadly force by Genevive Dawes that he reasonably believed to be threatening Jason Kimple or Zach Hopkins, and 2, the defendant reasonably believed that his intervention was immediately necessary to protect Jason Kimple or Zach Hopkins, then you will find the defendant not guilty and say so on the verdict form. If you do not so find, and you do not have a reasonable doubt thereof, you will reject the justification of deadly force in defense of a third person, and you will next consider the justification of deadly force by a peace officer making an arrest. 3.3. Deadly force by a peace officer making an arrest. A peace officer is justified in using force against another when and to the degree the actor reasonably believes that the force is immediately necessary to make an arrest if 1, the actor reasonably believes the arrest is lawful, and 2, before using force, the actor manifests his purpose to arrest and identifies himself as a peace officer unless he reasonably believes his purpose and identity are already known by or cannot reasonably be made known to the person to be arrested. Peace officer is further justified in using deadly force against another when and to the degree the peace officer reasonably believes the deadly force is immediately, page 7, necessary to make an arrest if the use of force would have been justified as described above, and, number 1, the actor reasonably believes the conduct for which arrest is authorized included the use or attempted use of deadly force, or 2, the actor reasonably believes that there is a substantial risk that the person to be arrested will cause death or serious bodily injury to the actor or another if the arrest is delayed. There is no duty to retreat before using deadly force justified in this manner. Now, bearing in mind the foregoing instructions and definitions, if you unanimously find from the evidence beyond a reasonable doubt that the defendant committed aggravated assault by a public servant as charged in the indictment, but you further find from the evidence or have a reasonable doubt thereof that, number 1, the defendant was a peace officer, and number 2, the defendant reasonably believed deadly force when and to the degree used was immediately necessary to make an arrest, and the defendant reasonably believed the arrest was lawful, number 4, and the defendant before using deadly force either A, manifested his purpose to arrest and identified himself as a peace officer, or B, reasonably believed that his purpose and identity were already known by or could not reasonably be made known to the person to be arrested. 5, and the defendant reasonably believed either the conduct for which arrest was authorized included the use or attempted use of deadly force, or B, there was a substantial risk that the person to be arrested would cause death or serious bodily injury to the defendant or another if the arrest were delayed, then you will find the defendant not guilty, and so say on the verdict form, page 8. If you do not so find, and you do not have a reasonable doubt thereof, you will reject the justification of deadly force by a peace officer making arrest, and find the defendant guilty of aggravated assault by a public servant as charged in the indictment, and so say on the verdict form. Presumption of innocence and burden of proof. All persons are presumed to be innocent. No person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or her innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. In all criminal cases, the burden of proof is on the state. The state has the burden of proving each and every element of the offense beyond a reasonable doubt. The state is not required to prove that a person is guilty beyond all doubt. The state must simply exclude all reasonable doubt about the person's guilt. If it fails to do so, you must acquit the defendant. Number 5, evidentiary instructions. The indictment in this case is no evidence whatsoever of the guilt of the defendant. It is a mere pleading necessary in order to bring this case into court for trial, and you will consider it for no other purpose. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted You are not to be concerned with the reasons for such rulings and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question, page 9 of law. In admitting evidence to which an objection is made, the court neither determines what weight should be given such evidence nor passes on the credibility of the witnesses. As to any offer of evidence that has been rejected by the court, you, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any act or word to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinion upon any matter of fact in this case, and if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, you must wholly disregard it. Our law provides that evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. In this case, evidence has been admitted that Genevive Dawes and Virgilio Rosales may have committed crimes, wrongs, or bad acts. You were instructed that this evidence was admitted only for the purpose of showing the possible motive of Genevive Dawes. You may not consider this evidence for any purpose unless you find and believe beyond a reasonable doubt that Genevive Dawes and Virgilio Rosales committed the crimes, wrongs, or acts alleged. Even then, you may only consider it for the purpose of determining the possible motive of Genevive Dawes, and you may not consider it for any other purpose. Hearsay is a statement that 1, the declarant does not make while testifying at the current trial or hearing, and 2, a party offers in evidence to prove the truth of the matter asserted in the statement. Hearsay normally is not admissible. In this case, certain hearsay information contained in records that were reviewed by expert witnesses was, page 10, admitted before you through their testimony. Such hearsay was admitted only for the purpose of showing the bases of the witnesses' opinions and cannot be considered as evidence to prove the truth of the matters asserted in the hearsay. Number 6, right not to testify. Every defendant has the constitutional right to remain silent. A defendant may testify on his own behalf if he elects to do so, but this is a privilege, and if he chooses not to testify, that fact cannot be held against him. In this case, the defendant has elected not to testify, and you are instructed that you must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Deliberations and verdict. Following the arguments of counsel, you will retire to consider your verdict. After you retire to the jury room, you will select one of your members as the presiding juror. It is the duty of the presiding juror to preside over your deliberations, to vote with you, and when you have unanimously agreed upon a verdict, to sign the verdict form accordingly. Your sole duty at this time is to determine whether the defendant is guilty or not guilty as charged in the indictment in this cause, and restrict your deliberations solely to the issue of whether the defendant is guilty or not guilty. During your deliberations, if you need to communicate with the court, please press the red jury call button and the bailiff will respond. Your communication with the court must be in writing through the bailiff and signed by the presiding juror. A suitable form for communicating with the court is attached to this charge after the verdict form. The court will answer any such communication in writing. No one else has any authority to communicate with you during your deliberations. Do not attempt to talk to the bailiff or the attorneys regarding any question you may have regarding the evidence, page 11. During your deliberations, you are entitled to view any or all exhibits admitted as evidence in this case. You may not have any testimony from the trial read back to you unless you are in disagreement about a specific statement or testimony of a witness. If during your deliberations you disagree among yourselves about the statement, testimony of a witness, you may ask the court to have the testimony about which you disagree read back to you from the court reporter's notes. A suitable form for requesting that testimony be read back to you is attached to this charge after the verdict form. It is only from the witness stand you are permitted to receive evidence regarding this case. You should neither consider nor mention any personal knowledge or information you may have about any fact or person connected with this case that is not shown to you by the evidence. You are not to use any other means or device to communicate about or research any issues in this case. You are the exclusive judges of the facts, the credibility of the witnesses, and the weight to be given their testimony, but you're bound to receive the law from the court which is given in this charge and to be governed thereby. The credibility of the witnesses and the resolutions of any conflicts and testimony are fact issues to be resolved by you, the jury. A suitable form for your verdict is attached. Once you have reached a unanimous verdict, fill out the appropriate verdict on the verdict form and then press the red jury call button. Signed on this, the 11th day of February 2020 by me, Brandon Birmingham, judge of the 292nd. Page 12, the next page would be page 12, but it says page 1 of 1 is the verdict form. Reads as follows. Cause number F17-00545. State of Texas versus Christopher Hess here in the 292nd Judicial District Court. Verdict form. We, the jury, unanimously find the defendant guilty of aggravated assault by a public servant as charged in the indictment, and there's a spot for the presiding juror to sign and print his or her name, should that conform to your unanimous verdict. Or, and these verdicts are mutually exclusive, we, the jury, find the defendant not guilty, and there's a spot for the presiding juror to sign and print his or her name. The next page is communication with the court. That's a form that you can use if you need to communicate with the court. If you have more than one note, feel free to use a sheet of notebook paper that Sheriff Martin will be providing to you. You can use that too. And the last page is a request for testimony to be read back. The law does not allow a rereading of testimony. Should you have a dispute, you need to delineate that dispute, and this is a good way to do it. If you have more than one dispute, you can use a different sheet of paper. However, the words on the different sheet of paper would need to reflect that dispute. Once we receive that, if you have it, it takes a little bit of time to get it back to you, but we'll go as quickly as they can. Since the state has the burden of proving their case to you, they get to open the arguments. It is my understanding that Mr. Mitchell is going to open the arguments. The court will recognize the Honorable Brian Mitchell on behalf of the state. Sir, this is your jury. Would you like for me to let you know when you've used a certain amount of time out of your 45 minutes?
Yes, Your Honor, if you could let me know when I've used 10 minutes.
Yes, sir, will do. You may proceed whenever you're ready.
Thank you, Your Honor. May it please the court,
You may.
opposing counsel, ladies and gentlemen of the jury. It's been a while since I've talked to you. I guess it's been a week Friday, and I wanted to talk to you today. My purpose of this open to close, and just to give you a roadmap, I'm going to get to talk to you for some amount of time. The defense is going to get up and get to argue for an amount of time, and then Mr. Lewis is going to come up and finish the argument. So that's kind of how this is going to go, all right? This document that you will take back with you is sort of your North Star. This is what is going to guide your deliberations, okay? And one thing that I thought was extremely important for you guys to consider, on page 10 it says, your sole duty at this time is to determine whether the defendant is guilty or not guilty as charged in the indictment in this case, in this cause, and restrict your deliberations solely to the issue of whether the defendant is guilty or not guilty. You know, I've sat through this trial, and you may have thought, like I did a couple of times, I'm not entirely sure who's on trial here. We've heard a whole lot about Genevive Dawes and Virgilio, but sort of an inordinate amount of time, in my estimation. So I want you to know that what you guys are tasked with, what you're doing, is determining whether this man, right here, this one, is guilty of aggravated assault by a public servant. Okay? Right here in the charge. It guides you. Here's something else. And I went through here and I highlighted some things, and I encourage you to do the same. If there's not a highlighter back there, I assume that the judge can get you one. We talked about in voir dire possible defenses. Okay, and I told you at the time I didn't know what would be in this charge, but now we know, and they're in here. There's a definition, reasonable belief. Highlight it. If there's a dry erase board or a chalkboard in the back, write it on the board. This is what you are tasked with identifying whether the actions that night were reasonable or not. This is the law. This is the definition. Anytime you guys are talking about things, you go back to this. It reads, reasonable belief means a belief that would be held by an ordinary and prudent man in the same circumstances as the actor. Not what another officer would do. Not what anybody else would do, but an ordinary and prudent man in the same circumstances as the actor. Ordinary, write down, go back to this. Everything is based on that. So, we've got some things we talked about in board hour. I want to kind of circle back to those things. For justifications regarding criminal conduct, much like this case, the defendant had to commit the offense. Okay? He had to, in this case, commit aggravated assault with a deadly weapon by a public servant in order to get a justification in this case, whether it be self-defense, defense of third persons, or deadly force to make an arrest. Okay? There must be a reasonable belief that it was immediately necessary at that time to use whatever force was used. Immediately necessary. We're going to come back to these. It also is based on a reasonable belief, which is what I just told y'all to highlight and put on the board. Here's what it's not. I told you it's not what another officer would do or another person would do. It's certainly not what he would do. So if someone goes back there and says, well, he did this because that's what he would do, that's not the standard. It's a reasonable belief. An ordinary and prudent person, not the defendant. Okay? I want you guys to focus in on that. All right? That is so important in these cases. These words have meaning. The legislature would not have given us this language if it didn't matter. Okay? So, when we talked about these defenses, self-defense, defense of third persons, and the use of force to make an arrest, we talked about this in board hour. There is no preemptive self-defense. Okay? It has to be immediately necessary. We talked about the fact that you can't use deadly force on could, probably, maybe. Those don't work. That's not in the charge. You will not see those words. So every time you hear defense counsel say, is it possible? Ask yourself, no. Was it reasonable? Okay? Those are different words. Reasonable is what guides you. Not possible, not might, not maybe. Okay? And you remember I put this up here. They deserved it. It's not enough. Okay? We heard a couple times in this trial that, well, you just wanted to go home to see your family that night. You as a police officer get to go home to see your family. What does that really mean? Does that mean that their lives are more valuable than ours? Sure sounds like it to me. But I can tell you what, she had a right to go home. She had a right to go home that night. They deserved it is not an excuse for taking a life. The fact that a gun was found in this van has no bearing on anything. That is simply a mechanism to get you guys to feel okay with justifying killing this person. If Officer Hess didn't use his weapon, she would have killed everybody with that gun. That's what they want you to think. The reality is it had no bearing on anything. It had no bearing on anything. Probably doesn't equal reasonable. Okay. You don't have to memorize these. These are in the charge. Okay? And I'm not going to go through each one of these with you. Just know that all these that we talked about in board hour are going to be in the charge. Okay? So, but I do want to focus on a couple of things. I went through and highlighted every single time that there is a reasonable belief and immediately necessary. Every single defense has those two elements. It must be based on a reasonable belief that deadly force has to be used because it was immediately necessary. All of these All of these require that. If they do not have an immediacy, if it is not immediately necessary to use deadly force, you don't get the justification. Period. The inquiry stops there. You have to have it on all of them. The only difference is on the deadly force to make an arrest is that last one. There is a substantial risk that the person arrested not might, not possibly, will cause death or serious injury. That's the only difference with this one. You still have to have reasonable belief, and it still has to be immediately necessary. Okay? If you think that Officer Hess used deadly force at a point in time when it was not immediately necessary, all three defenses failed. It's just that simple. Jonathan Priest came up here today and he talked to you guys about whether or not Officer Hess's actions were reasonable or not, in his estimation, based on his years of training and experience on this. And he told you at that point in time that it was not immediately necessary. We heard many officers get up here and testify that when that car was backing up, nobody was behind that car. Nobody was behind the van. It was objectively impossible for that car to cause serious bodily injury or death when it was backing up the second time. We know that because there was nobody behind the car. So the question is his belief that there was somebody behind the car reasonable? Okay? I will submit to you that it's not. Here's why. There was talk about tunnel vision. Remember this. When you go back, you can watch these videos. Officer Hess takes control of that situation. He's directing traffic.
You've used
Okay?
10 minutes.
Thank you, Your Honor. If he has such tunnel vision, how does he know to tell the other officers to get back? It's because he sees them. Okay? He sees them. He's directing traffic. He knows where they are. And I'll submit to you, even if he doesn't know exactly where they are, he knows where they're not. They are not trained to get behind moving cars. He knows that. He's had over 1,000 hours of training. He knows that. And you know what? He relies on his fellow officers to follow those same rules that he follows. So although they may not be able to tell you where everybody is, they know where they're not. And that's behind that car. These are the things that have to guide you guys. You have to decide at that moment in time. At the moment in time he started firing 12 shots, was it immediately necessary at that moment in time? If you get back there and you say, it was not immediately necessary because nobody was behind there, then your inquiry stops. It's over. He doesn't get the benefit of any of these justifications. These words have meaning. You guys take that charge, you pour through it, and you follow the language within that charge. And I know when you get done, when you're done with your deliberations, you will find that the justifications do not apply to this defendant. And you will find him guilty of aggravated assault by a public servant. Thank you.
Thank you, Mr. Mitchell. The court will recognize the Honorable Reed Prosper on behalf of the defendant. Mr. Prosper, how much time would you like for me to let you know when you've used?
Let me know when I've used 20 minutes.
Yes, sir. May proceed.
Ladies and gentlemen, I want to thank you for your patience, the time that you've spent listening to the facts of this case. If I thought I could get by with pulling up a chair and sitting down and just having a conversation with you, that's what I'd do. I long since quit flattering myself to think that I was going to make any comments that was going to change the opinions or mindset that you got about listening to this case. Your collective intelligence and judgment about what you've heard, the common sense that I know you're going to employ in this particular matter, far transcend any, I graduated in the bottom half of my class words that I might have to tell you at this point in time. I have a few comments I want to start off by just answering Mr. Mitchell, and then I'm going to go to the court's charge. These won't be my words, these will be the judge's words. He stood up here, and basically, if you look at what he says, the first thing he says is he wants you to ignore the conduct of Genevive Dawes and Virgilio Rosales. And I was talking to my wife the other night, just telling her generally short Reader's Digest version about the facts. And, you know, at some point in time, she looked at me and said, "Isn't it ironic?"
I'm going to object at this point with regard to anything his wife said.
All right, you're not, the objection's overruled for purposes of illustrating. Go ahead, Mr. Prosper.
Isn't it ironic that the people that created the facts and circumstances surrounding this incident, that is, the ones that set it all in motion, that caused the conduct on behalf of the other officer's safety, that Officer Hess had to use because they put him in this position? Isn't it ironic that he's the one that's on trial here? And you know, folks, that pretty much capsulizes it all. That pretty much capsulizes it all. Mitchell asked you to find whether or not the actions are reasonable. Now I'm going to ask you this. Is there anything that one of you could possibly point to that the occupants of that vehicle did that were reasonable that evening? What would a law-abiding, upstanding, not committing crimes, not scared of what you're going to find in this vehicle, not scared of what punishment I'm going to be looking at because of my actions that led them to be here to begin with, wouldn't have rolled down the window and stuck out their hands? And if you've been on the force, I don't care whether it's 10 days or 10 years, your apprehension level, and you're going to be sitting there thinking, just like Joe Samples, Joe Ordinary Citizen, was. What are they hiding? Why aren't they complying with the commands? And I know, I'm glad it was brought out, that one of y'all back in that jury room during your deliberations would have said to the others, you know, if they had just pulled that car up to the rear bumper of the Dodge Journey, they couldn't have moved, they couldn't have left. Why didn't they do that? Well, now you know why. It's an order from the city that they not do that. It's a fireable offense. It's basically the city saying, we don't want our property damaged by them backing into it. We value that more than we do the lives of the officers. It's a misguided policy by people that sit in a well-lit room and don't go out on the street and don't have to deal with the Genevive Dawes and Virgilio Rosales of the world. She wasn't going home that night. He's saying, well, don't you know she would have liked it? She wasn't going home that night, folks. Best case scenario, she's going to jail for multiple felony offenses. What can they be thinking? each and every one of those officers out there on the field said they were desperate, they would do anything, and were doing everything to get away. Again, not the norm for law-abiding citizens, and again, increasing the anxiety level. And getting back to who put them in the position, who put Officer Hess in a position where he has to tunnel in, focus in on that car, so that, in the words of their expert, an expert that's paid a bunch of money, and don't you know he's figured out that if I come down here and don't toe the company line, I'm not getting called anymore. And yet in 3 years, he doesn't think it's important. He doesn't think it's necessary to interview any of the officers that were out there. And I'm going to go into that in a minute. I'm going to go into all the witnesses. And each and every one of those people, police officers on the scene, civilian that was on the scene, officers that weren't there but looked into this, come to the same conclusion. Come to the same conclusion, folks. That those officers were at risk, their lives were in danger, and I forget which officer it was, I may be able to find it in here in a minute. Something bad was going to happen if Officer Hess hadn't acted, and officers were going to get hurt that evening based on the actions of the two people that were in that car. And again, you've got to be asking yourself, why? Why would they continue to get away? You know, I'm kind of like Joe Samples. I get up in the morning at 4:45 and I walk my dog. And if I'd have gotten up, or anybody, local track team doing cross country, somebody walking their dog, if they had been walking that animal or running on the other side of that fence that evening, as she accelerates and tries to go through that fence, thinking that she was going to be able to because it's flimsy and it's dilapidated, she's got no way of knowing that there's a wrought iron fence on the other side of it, or storm fence. And she had gotten through and injured one of those kids on the cross country, injured me and my dog, injured somebody. You all would have been sitting there and you all would have had one thought. Why didn't they shoot? How many more red flags would there have to be before we're going to stop this madness? Are the inmates just running the asylum? Is that what we need to turn it over to? Should all the officers just turned around and looked at each other and said, gosh, bad day for us. They just don't want to comply. They don't want to listen to us. I guess we better get in our cars and leave. And let them continue the crime spree. Let them continue putting people at risk and just go on about their business. Is that what you want? I don't think so. I don't think so. He says, you've got to find, if you don't find that there's a substantial risk, a person that will cause death or serious bodily injury, what do you think they were heck bent on causing if they could have gotten through that fence? Or they could have gotten that car turned so they could have headed out. Somebody was going to get injured. Somebody was going to get injured. And again, they keep talking about Hess's belief, is it reasonable? Their own expert tells you, again, that it is. Because when you get the tunnel vision and you're taught to focus on the threat and not take your eyes off that threat, I forget what words they use, but basically it blurs or blocks out your peripheral vision. They put him in that position by their actions. And so when he's shooting, he can't see that they've moved. They cause that. Now, let me tell you what the court tells me before I get back onto the evidence and witnesses in this case. An indictment is no evidence of guilt whatsoever. I told you the court would put that in the court's charge and give it to you. These are not my words, these are the court's words. All persons are presumed innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or otherwise charged gives no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant. Now, as you've had a chance in this particular case to see the presentation of witnesses, to see the questions were asked, which of these two tables would you count on to bring you the whole story, to try to get the facts out, to try to let you know exactly what happened? Because what you saw up here and heard from several officers is we told them. We told them what went down. They didn't want to hear it. And how's their way of dealing with that? They just don't call them. They just think, you know, they can pick like little snapshots out of all of the evidence and throw that at you rather than you have the whole picture, because the whole picture doesn't suit their purposes. The whole picture tells you this man's not guilty. The state must simply exclude all reasonable doubt about the person's guilt. That's what the judge tells you. That's another way of saying you must be 100% free of reasonable doubt. 100% free of reasonable doubt. Again, you view this from the actor's standpoint. No person said out there at the scene that I don't understand why there was a shooting in this case. The people that didn't shoot tell you they either would have shot but didn't because they weren't in position, or somebody was in front of them, or they were blocked. But had they not, there at least two of them said we would have shot. They put on the Lane Evans to try to say, I didn't perceive a threat, therefore there was no threat. That's not right. That's not the way that it was. She told you on cross-examination, not through something they brought out. I was getting out of the way. I was not in a position to shoot because of the position I was in. That's why I didn't shoot. Not that she said, I'm not saying that there was no threat. It's just that I wasn't threatened in the position I was in. Now, folks, I was trying to listen and write. And yeah, my hearing aid batteries went out. But if I'm saying something that's not the way that you heard it, this lady right here took it all down. She's going to throw something to me for telling y'all this, so she'd have to go back. If y'all have a dispute, she gets to type it up, and let me promise you, she didn't miss a word. But y'all have the ability, if you think I'm saying something that's not the way that it is, to go back and get it. And I urge you to do so if you have doubts. And you get down to the fact of justification. And now, they wanted to trot out in the autopsy. Remember the medical examiner that came in here and they said, well, did you have a manner of death in this particular case? Yes, we did. What was that? Homicide. And they would have loved to have left it at that had y'all gone back and said, ooh, the medical examiner said this was homicide. He must be guilty. That's not what he said. He said homicide just means that this person died at somebody else's hands. It's not a conclusion about a legal definition or about the facts of this case. It's merely a homicide. He then added, of course, there's justification. Just like it's 3 a.m. in the morning, somebody's creeping up your stairs, and they're armed, you've got a right to go out and shoot that individual if you feel it's immediately necessary to protect your family. It's justified. That's what we have right here, justification. Just like homicides, autopsies, homicides can be justified. And the judge tells you that 3 separate instances in this particular fact situation that apply. Deadly force in self-defense, deadly force in self-defense of a third person, and deadly force by a peace officer making an arrest. It is a defense to prosecution that the conduct in question was justified. You are instructed that a reasonable doubt on the issue of justification requires the defendant be acquitted. The defendant is not required to prove that the conduct was justified. Rather, the state must prove beyond a reasonable doubt that the justification does not apply to the defendant's conduct. A person who has a right to be at a location where the deadly force is used, who is not provoked. Hess has a right to be there. Hess didn't provoke this conduct. And he's not engaged in criminal activity at the time the deadly force is used, is not required to retreat. He can stand there as a reasonable person charged with protecting the public and try to talk sense into people that ain't having none of it and try to keep them from doing what these other officers told you they were going to do if Hess's action hadn't saved lives that night. And like Samples tells you, they were desperate. They were not complying with anything, and what is going to come out of that vehicle next is what he told you. And you've got deadly force to protect a third person. The actor reasonably believes it's immediately necessary to protect that third person. And what do the other officers out there tell you? That's where we thought they were. It was a reasonable belief. He's thinking it's immediately necessary. Okay. They know. You now know that they know. And they've had 3 years to talk to Virgilio Rosales. 3 years. If there is a fact that would have come out of his mouth that would have benefited them, you'd have heard it. They know they will be arrested. These people in the car know they're going to be arrested for a stolen vehicle, a stolen gun, and evading arrest. Now you think about it. The normal things, if you're a law-abiding citizen, you're not going to violate the law because it's not the right thing to do. They way beyond that. They don't care. The fact that they're facing 10 years in the pen is no deterrent to their actions that evening. What does that tell you about their mindset and the lengths they will go? And if they had gone out there and gone through the fence, some supervisor is going to be looking at Hess and saying, how many more red flags would you need? Now, what's there? What do they do with people that don't suit their purposes? Officer Embry, veteran with the Sheriff Department. They've used him before. His figures don't match what they need for their theory of the case. Now, do you think they're going to call him? Or what are they going to do? Man, we got a problem here. We got a problem here. Tell some investigator, get on the phone, find somebody that'll take whatever money it takes to get down here. and we'll just pretend Emory doesn't exist.
You've used 20 minutes.
Thank you, Judge. This is in the Code of Criminal Procedure. But they want to treat the truth and evidence like hot and cold running water. When it suits their purposes, they'll turn it on. When it doesn't, they're just going to pretend it doesn't exist. We don't think y'all need to bother yourselves with this. It doesn't help our theory of the case. Let's look at all of the reasonable things, and I've got to sit down here very quickly. Lights on car, holler Dallas police, show us your hands multiple times, pull the car up. Remember, you can't block the car. Siren, air horn, continued calling, try to open the door. They don't shoot when the car gets hit. They don't shoot when they try to run through the fence. They continue to holler. He perceives the risk. He shoots. Now, what's the first thing? You can go back and play the body cams of this. What's the first thing? And I didn't have a stopwatch on it, but I guarantee you it wasn't, 3 seconds. What's the first thing that comes out of Hess's mouth after he fires those shots? Shots fired, because that's a requirement anytime an officer discharges a firearm, that be reported. So he's got it. Calls for an ambulance, and is everybody all right? What does that say about his perspective? What does that tell you about his judgment? And let's compare that to Virgilio Rosales. They get him out of the car. They do what prudent officers do. Walk toward me, walk toward me, walk toward me, get on the ground. Is there a gun in that car? No. He's lying to the end. He's hoping that they will just put him back in that seat and go about their business so he can get his hand on that gun. That's the mindset of Rogelio Rosales. He's lying to the end. Again, compare that to the judgment of Christopher Hess. Folks, y'all, I've got other stuff I could talk about, but I'd start repeating myself. What you need to know is, in this particular case, of the people that were called to testify, Aaron Evans, not saying that there was no threat. Again, she can read it back. Not saying that there was no threat. Lickwar. No doubt Hess prevented someone from getting hurt that night. Strongly believe the vehicle would have injured a police officer. Hopkins. Situation posed a risk, and I told them I would have shot. Joe Samples. She had a lot of opportunities to get out of the car and stop. Why are they not complying? Officer Kimball tells you, I'm worried about what's going to happen next. Christopher Aldridge. If Hess not in front, he would have fired. Believe officers are at risk. They didn't call him. They didn't want y'all to hear that. And you had a chance to observe him. You had a chance to observe his demeanor, his judgment, his common sense. Folks, I'm going to ask you to take that charge back, to read it. If you've got any questions, get her to play it back. And again, ask yourself the question. We have no burden of proof in this case. But we've done everything we can possibly do to bring you all the witnesses that will paint a picture of what went on out there that night. And this man right here, actions were taken to protect the others that were out there. And again, I get back to the statement of my wife. Isn't it ironic that he's here because of a situation created by a lawless criminal. We don't care about anything but ourselves. I'm going to ask you to find him not guilty, not because I say he's not guilty, but because when you read the law in this case and you apply it to the facts, all of the facts, that's what verdict is called for. Thank you again for your patience. Thank you for your attention.
Thank you very much, Mr. Prosper. Court recognizes the Honorable Messina Madsen. Ma'am, you have 20 minutes. May proceed whenever you're ready.
On January 18th of 2017, Genevive Dawes was armed, she was aggressive, and she was unwilling to be arrested. That's the way I started this trial. And I will tell you that everything I've told you still stands true. You see, here's why it's important. Here's why what was going on in that car is important. Counsel stood up and told you you have to figure out what is reasonable. Go through the charge and highlight what is reasonable, whether or not it's reasonable. And you judge it from the officer's standpoint. A reasonably prudent person in his shoes, a reasonably prudent person that's answering a 911 call and observing. And you look at it from the totality of the circumstances. You look at it all together. Here's what's so important about what's going on in that car. He's right. He's coming to the correct conclusions. He's coming to the right conclusions about what's going on in that car. You see, he's having to make judgment calls on a rapidly escalating situation. Why are they not complying? Do we need to be louder? We have to identify ourselves. Dallas Police, show us your hands. The hands are the threat. They know the hands are the threat. Well, guess what? They're right. There could be a gun in that car, and we're worried because we can't see in. Guess what? They're right. It's reasonable. Why aren't they coming out? There must be something bad in that car. They have to be coming up with a plan of what they're going to do next. These are all of the things that they're trying to figure out as they surround that car and still try to think about where they are and whether or not they're fanned out appropriately. And they're coming to the right conclusion. This is about to get out of control. Remember Officer Ayla, she told you the moment the car turned on, this is about to get out of control. I'm going to ask you to do one thing, and this is important. I want you guys to go back and watch those body cameras. I want you to take yourself back into that situation. I want you to look at it from different viewpoints. Here's what's important. We all thought it was jarring when those officers were yelling. We all thought, oh my gosh, what are these people doing? Why are they not getting out of the car? We hear the officers as they're trying to trade information. We see the officers get closer and think, oh, this is weird. There's something weird back up. It's a dangerous situation. You see the officers fanning out. Take yourself back into that moment because that's the moment you're judging. What is reasonable at that time with all of the information that they have? Take yourself back there. Watch multiple body cameras. Don't take my word for it. I'm not testifying for these officers. I had them step down and say, why is that important? Why were you observing that? Y'all take yourselves back there. Realize that each of them was perceiving different things. But they all thought, this is weird, something's escalating, they've got to be hiding something in that car. This is getting out of control. They were all thinking it because it's the reasonable thing to think. They're all thinking it because it's true. It did very rapidly get out of control. And you know who was calling the shots? The occupants of that car. See, the occupants in that car were making decisions. They were making decisions on where this was going to go. and you have heard evidence and you get to hear it in the charge, you can consider all of that evidence when you're deciding the mind and the motive of the occupants of that car, which means that you get to consider that she has meth in her system. You get to consider that she has heroin in her system. You get to consider her drug-induced clouded judgment of the calculations. That there's a gun in that car. And that for either of them to possess that gun is a crime. That that gun is also stolen. That that car is stolen. And that if they get out and the officers find all of their activities, they're going to jail. You see, because then they begin to act on that. They begin to use force against those officers. Genevieve Dawes, in her drug-induced state, decides, I'm getting out of here. I'm driving this car out of here, and it doesn't matter who gets hurt. Baby, it's you and me, and we're getting out of here. Baby, it's you and me, and we're in this together. Hang on. In my opening statement, I told you that I believe that the state would make a strategic choice to not call Virgilio Rosales as a witness. That's important. You see, they have the burden. They have the burden to show you that what Christopher Hess was looking at that night, what he was thinking, was unreasonable. You should know it was a strategic decision to not introduce you to who Christopher Hess was really dealing with that night. It was a strategic decision to not show you who they were dealing with that night. It was a decision to hide this man and what you could learn about him from you. And you can hold it against them. You can make reasonable deductions from the evidence. You can decide that that's not right. That I have doubts. I have doubts about what those people were planning. You see, you're in control. You are the ones who decide what is right and just. And when they make a strategic decision to hide things from you, there are consequences. And I'm not in a position to get to call him. I'm not in a position. I don't have the power. Those two had the power that night. They had all of the power in that car to do exactly what Joe Sample said. Just get out. Just get out. They had so many opportunities. Just get out of the car. They didn't. Genevieve Dawes made the decision to turn on the car, put her foot on the brake, put it in reverse, and hit the squad car. You take yourself back to that emotion, you have to think, all right, you're not getting that car out. Come on, just get out of the car. It's what's reasonable. It's not what she did. Put on the brake, shifted it into drive, and hit the accelerator. And got as much speed as she could to try to ram through that fence. But she couldn't get through. And then she made this last decision. This decision puts us here. I want you to go back and remember what the officer said about this moment. None of them know exactly where each other are. None of them know exactly where every officer is. But they all are zeroed in on this car. They all are zeroed in on this threat. They all are zeroed in on what is going to happen with this car. And she puts that car in reverse, and she puts her foot on the accelerator, and her foot has the power of inches and life and death over those officers. That's the moment you're looking at. That's the moment. They've shown you what their intent is. They've shown you they're not going to comply, and her foot's on the accelerator. Action will always be faster than reaction, ladies and gentlemen. Action will always be faster than reaction. And in that moment, Officer Hess does make a decision. She's had every opportunity to stop. They've had every opportunity to comply. And when she hits that gas, my fellow officers are in danger. And it's a decision. It's them or the occupants of the car. Them. I either protect them. I either do what is expected of me. I either do my job and protect my fellow officers. Or I let her push that gas and possibly run over them. That's the decision he makes. And I'm going to tell you that you're going to have to make a judgment call about his character. You have to. That's what you're asked to do. You're asked to judge this man right here. You're making a judgment call about him and the decision that he made in that moment. And I'm going to tell you that probably the most important thing is right after. Right after, when his heart's still pumping and he has had to fire that weapon, he is still saying, "Shots fired, get the ambulance here." Because I understand the value of life, and I understand how hard it was to make this decision. And I don't care who they are in that car. I had to stop them, but I have to get them help. That moment speaks to who he is. That moment tells you that this was a hard decision for him. That moment tells you he did not take it lightly. Shots fired, get them help. Get them help. And then he begins to ask about his fellow officers, and you hear him say, "Is everybody okay?" And you see his leadership, and you see that he is the most senior officer, and you see what he is trying to balance, and you see him trying to remind them, "Guys, somebody get the ambulance in here. We have to get the ambulance in here. Keep your eyes on him. Do you have a weapon? This is still a dangerous situation." And he has 5 young officers that he feels responsible for. 5 young officers where he is trying to handle it all and make the hard choices. Get them help. Keep your eyes on her. I found a holster. This is still a dangerous situation. Pat him down. Get them help. Keep your eyes on her. There's a gun in there. And he's trying to balance it all. Officer Hess was exemplary that night. He remembered what was important. He valued human life, and he made the only choice that was available to him. The only choice that was available. I told you at the very beginning of this trial that this was a tragedy that Genevive Dawes was determined to drive into. My God, don't you wish she wasn't? My God, don't you wish that she made any other choice? Don't you wish we weren't here? But it was her decision, her determination, her choice, time after time, that makes this a not guilty verdict. She was determined to drive into this. And it didn't matter who was going to get hurt. And it didn't matter that those officers were behind her. She was determined to drive through it. Her decisions make this a not guilty.
Thank you, Ms. Mattson. The court recognizes the Honorable George Lewis on behalf of the state. Sir, is there an amount of time you would like for me to let you know that you have remaining?
We have a 5-minute warning.
Yes, sir. You may proceed whenever you're ready.
How much time do I have, please?
You have 45 minus 12 is 33 minutes. 26 minutes until your warning. Go ahead.
All right, thank you, Your Honor. May it please the court, counsel. Ladies and gentlemen of the jury, good afternoon. On behalf of the District Attorney's Office, citizens of Dallas County, and most importantly, this family over here, the family of Genevive Dawes, we want to say thank you first and foremost for your time and your effort. It's been a week. You've heard a lot of testimony, seen a lot of evidence. And we know that you don't take this case lightly due to the magnitude of it. So first and foremost, thank you. Thank you for your time and your attention. When Mr. Mitchell got up here in his opening statement, he told you what they were going to say. He told you that the defense attorneys were going to get up here and say that they deserve it. They put this defendant in a position to use deadly force. They caused all of this. Mr. Prosecutor says that he didn't want to do this, but they put him in this position. The defendant was a Dallas police officer tasked with answering calls and dealing with incidents that come up on a day-to-day basis. If he didn't want to be in this situation, and if he didn't want to deal with it, don't be a Dallas police officer. Nobody asked you to sign up for this. That's what you're supposed to do, but you're also supposed to follow the law. Police officers are not exempt from following law, just like you and I. The laws of self-defense, defense of third persons while using deadly force, that applies to him and other police officers just like it does us. They put him in this position. Okay, I'm not getting up here and saying that we condone the actions of Ms. Dawes that night. Stolen vehicle, stolen gun. Obviously, we don't condone that. But at the end of the day, you cannot use deadly force because somebody's in a stolen vehicle. Okay? You can't use deadly force and shoot and kill somebody because they have a gun in the car, even if it is stolen. Especially when that information comes to light after the fact. Now, the defense gets up here and harps on the fact that there's a stolen gun found inside this vehicle. Okay. Yes, officers don't know what's inside this vehicle, but each and every officer who testified on this stand for you under oath this week told you that gun did not play any decision, any factor whatsoever in the use of deadly force in the situation. That gun was found after the fact. Even the lead detective, Dale Richardson, got up here, swore to tell you the truth on this stand, told you about all the experience that he has, and he told you that gun did not play any factor whatsoever in the use of deadly force. Again, what you're tasked with deciding is at the moment in time this defendant used deadly force against Ms. Dawes, was it immediately necessary? So take the gun, set it aside. That's not what you're here to decide today. And as pertains to the actions of Ms. Dawes as she operated that motor vehicle tonight, I told you in opening statements that you'll get to see this particular shooting from many, many angles based upon the 5 officers who had on body-worn cameras at that time. And you got to see that for yourself. They want to get up here and say that she was desperate to get out of there. She was willing to do anything, including mowing over officers. Is that really what you saw in that video? Is it really? I asked those officers, if she really wanted to run over some officers, she could have gunned and pressed that gas to the floor. Could she not have? Of course she could have. And we're talking about ramming this vehicle. Is that really a ramming? Really? I think what we pointed out, and you guys understand, is that this defendant, Mr. Hess, got into that squad car, pulled it up, okay? The vehicle comes on. The reverse lights actually come on before he pulls up. And as he pulls up, she pulls back. Okay? And the vehicles collide. But that's a ramming. And if you also recall talking about credibility and somebody lying, he says on the radio they ran the squad car twice. Well, we saw that wasn't true. You see, you get to judge his credibility as well. And that's part of it. So let's kind of start at the beginning. Let's start with Mr. Samples. He told you that he recognized this vehicle from the day before. It's approximately 10:30 the morning before when he observed this vehicle. He looked inside, he saw Ms. Dawes and Ms. Gonzalez sleeping inside this vehicle. They had on a leopard blanket and they were sleeping inside this vehicle. Okay, that's what he testified to. He was concerned, called the police. Police got there and they responded. Now, Officer Alish, let's start here. Let's talk about the tactics that the officers used. Everybody described how this is such a dangerous situation. We don't know what's going on with this vehicle. We have to be cautious. We have to be vigilant. So we pull up the squad car for cover, right? That squad car is there to cover us just in case somebody starts shooting outside this vehicle. But that's not really what we saw in the video. You're looking at a screenshot from Officer Hopkins' body-worn camera, State Exhibit 4. Okay. This is right after Officer Hopkins goes up and pulls the car door on the car. Right? But this is such a dangerous situation that we're going to walk right up to the car, even though the squad car is here. We're using it for cover, right? That means you get behind it. No, they're right up on the vehicle. He pulls the cargo camera. Talking about Officer Alish, why we didn't call him. Again, credibility. Y'all saw his demeanor on this stand yesterday. He tried to tell you that when I made the statement, okay, it's occupied, they're sleeping. I have no idea why I would have said that. Maybe I was relying on what the call sheet said, or I don't know why I would have told officers that. So my question to him was, isn't it important for officers on the scene to have all the information? For you to be as accurate as possible so you can relate to the other officers what's really going on this extremely dangerous scene? Well, yeah, I would agree that that's important. But again, I don't know why I would have said that. Well, I submit to you he said that because it was true. It's occupied, they're sleeping. He's looking right inside the vehicle. They're sleeping. How do you know they're sleeping? When Mr. Gonzalez gets out of the vehicle, there's that leopard skin blanket that Mr. Samples told you about. And we saw them sleeping the day before. The seats inside the vehicle are reclined, consistent with them sleeping inside the vehicle. Okay? So, they're sleeping inside the vehicle. At some point, we know that they hear the commands of the officers because they started the vehicle. Let's talk about the manner in which she is operating this motor vehicle. Again, the defense wants you to believe that she was totally desperate to get out of there and she would do anything to get out of there. But what did we see on the video? Let's start with this. discharging firearms at a moving vehicle. Straight out of the Dallas Police Department General Orders 906.02, discharging firearms at moving vehicles. Discharging firearms at a moving or fleeing vehicle is prohibited unless it's necessary to prevent imminent death or serious bodily injury to the other officer or another person. Officers will not voluntarily place themselves in a position in front of an oncoming vehicle where deadly force is a probable outcome. When confronting an oncoming vehicle, officers will move out of his path, if possible, rather than fire at the vehicle. Straight out of the DPD General Orders. So let's talk about what some of these officers said. Officer Erin Evans, what did she tell you at the moment in time this defendant decided to use deadly force? She did not see a threat when the vehicle reversed the second time. That's what she told you. She told you that she expected the other officers to move out of the way of the vehicle. As they're instructed, as they're trained, as they're required to do under the general orders. And that's exactly what she did. That's exactly what Officer Alice did. That's exactly what Officer Liquar did. That's exactly what Officer Hopkins did. That's exactly what Officer Kemple did. And that's exactly what this defendant did. They all moved out of the path of the vehicle. She told you she did not know why the shots were being fired. Again, because she did not perceive a threat at that time. There was testimony about, again, officers not knowing where everybody else was at the time. And that's accurate. But again, immediately necessary. You cannot fire on possibly, you cannot fire on probably. If you're not sure whether or not there's an officer over there, you don't fire. It's as simple as that. Mr. Mitchell said it in his statement. Again, he may not have known that they were over there, but he sure knew that they were not over there. He surely knew that they were not over there, again, because based upon those general orders, they're not supposed to put themselves in the path of the vehicle. Officer Liquar, what did he tell you? The vehicle did not pose an imminent threat while it was backing up the second time because he could see that there were no officers immediately behind the vehicle. He told you that. He expected the other officers to move out of the way of the vehicle, just like Officer Evans testified to. Officer Hopkins did not shoot because the vehicle was not coming at him or other officers. The vehicle was not being used as a weapon when it hit the fence. The vehicle was not being used as a weapon when it reversed the second time because there was nobody behind it. These are the facts.
Any around Secretary of the uniform report.
If you saw and paid attention, as she begins to back the second time, the brake lights are being activated. You can see that she's being very careful when she backs out of that parking space. Besides the fact that you know at this point, based upon this testimony of Mr. Jobs and Mr. Partain today, that that vehicle was going at a max of 3.1 miles per hour walking speed, you know that she's being careful. First of all, based upon the video evidence, as well as that's consistent with what Mr. Sackler said on the stand. He said that when I saw that vehicle back and I saw the brakes activated at least one time. And that's what you just saw in this video. Not only that, the medical examiner testified that gunshot wound number 1, the exit of it, is consistent with a re-entry into the entry of gunshot wound number 3. Not only that, but it's consistent with someone who's turning to look backward as they're backing. So you have the gunshot wounds that are consistent with her turning, looking to see what's behind the vehicle. You have the speed of the vehicle, 2.5 to 3.1 miles per hour, walking speed. You have Mr. Samples telling you that the brakes are being activated, and you have the video evidence showing you that the brakes are being activated as she's backing the vehicle. Now ask yourself, based upon all this evidence, is that someone who is desperate to get out of there to run over officers, to cause destruction of property, and to go all out to get out of the situation. I will submit to you that it's not. Going back to these officers' positions, and Mr. Mitchell stated this as well, based upon the video evidence, Mr. Hess is telling the officers, move back, move back. Okay, now we can see on the videos that you have 3 officers to his right-hand side. You have Officer Lickwart, who's on the passenger side of the vehicle. You have Officer Evans, who's on the passenger side of the vehicle. And you also have Officer Alish, who's going towards the back side of the vehicle. And so who is he talking about? Get back. Those officers are in a position of safety as well as he is. He's talking to Officers Hopkins and Kemple, who were behind the vehicle. Yet the defense wants you to believe he's in such a situation where he's in this mindset of this tunnel vision, where he has narrowed his focus so much on this vehicle that he can no longer see what's going on. But he's talking to these officers, telling them to get back, which is exactly what they did. Now let's talk about this tunnel vision for a moment. The defense would have you believe that this tunnel vision causes you such where you're not aware of your surroundings anymore. Okay? Mr. Priest testified that yes, there is such thing as tunnel vision. It does affect your peripheral vision. However, that is not an excuse. That does not excuse you to go all out to use deadly force in any situation. Think about that for a second. They're saying that his peripheral vision is cut off such to the fact that he can use deadly force without having a reasonable belief. In other words, I'm so focused on this right here that I don't have to take into account what's behind the vehicle, what's in front of the vehicle. I can fire indiscriminately at that point because I have tunnel vision and I'm so focused on this. That's not appropriate, and that's not right. Again, based upon the law, immediately necessary, based upon the circumstances that were given at that moment in time. Officers are trained to consider their target and their background. Okay? Again, we know based upon the evidence in this case, they cannot see inside this vehicle. They told you that many a time. Why? Because the windows will fall down. So when you're considering your target and your background, you have to consider other occupants of the vehicle. You have to consider what's in front of the vehicle, what's behind the vehicle. But he didn't do any of that, because if he did, he wouldn't be here today. He wouldn't have fired his gun. Because based upon the video evidence, Officers Hopkins and Kemple had moved well before he decided to use deadly force in this case. Again, going back to the speed of this vehicle. Focus on Officers Hopkins and Kemple.
Back up, back up.
And he ran the like security bag uniform and arm.
Don't move! And back!
You don't need an expert to tell you that a vehicle going 3 miles an hour can cause serious bodily injury or death. You don't need somebody to come in here with a bunch of degrees and tell you that. Okay, it's obvious that if you're in the path of the vehicle going at that speed, if you're laying down, if you're not paying attention, it can harm you. That's not the issue in this case. The issue in this case is whether or not the defendant used vigilance to determine whether or not it was immediately necessary in that situation to use the deadly force. And we know that based upon the evidence, he didn't. Okay? He had ample time to either look in the direction of where the path of the vehicle was going. If he would have did that, he would have saw that there were no officers back there. He didn't have to turn his head, peripheral vision. Take a quick glance over there, and you see that there are no officers behind the vehicle. No other officers besides him and Keppel fired shots. And they told you why they didn't, because they didn't perceive the threat. Let's talk about Officer Keppel and his shot. He shot one time. Based on the physical evidence that we brought you, we were able to prove to you that his shot did not hit the victim, okay? It lodged in the door frame of the vehicle.
I would object, that's a misstatement of the evidence. The witnesses in fact stated that they didn't know who shot.
Members of the jury, you'll recall the evidence as you see fit. Go ahead.
April Kendrick testified that the bullet that was taken from the frame of the vehicle matched his gun. John Priest, our use force expert, testified that it is not normal. It's not usual for an officer to shoot one time. They're trained to double tap and reassess. So I asked yourself, why did he shoot one time? Well, the explanation for that is very simple. Sympathetic fire.
Judge, I'm going to object to that. The evidence is from Kempel's mouth is the reason he didn't fire but one time is that Hess, he could read the name on the back of his jacket, and that's why he didn't fire.
Right.
He had to that twice.
The objection is overruled. Members of the jury, you'll recall the evidence as you see fit.
Sympathetic fire is where something stimulates you and you have an involuntary reaction to it. Let's talk about Kempel's testimony. He told you that he stopped firing because he felt as though the defendant was in front of him and he didn't want to fire on him. Go back and look at the video. I ask that you do look at that. If you look at his actions after he fires that one shot, his firearm stays trained on that vehicle as it goes backwards, and he actually tracks it. The defendant didn't move 1 inch, but he's telling you that he stopped firing after one shot because the defendant was right in front of him. Again, credibility. You have the right to judge each and every witness who testified in this case based on what they told you on this witness stand. It's based on their demeanor. It's also based upon what they told you, whether or not it made sense. And I will submit to you what they told you about that one shot. Did not make sense. Police officers are trained that they are to be responsible for every single round that comes out of their firearm. Every single round. They have to be justified. Again, based upon the general orders, you're not supposed to be firing inside moving vehicles. Your first thing to do is to move out of the path of the vehicle. And each and every officer testified that they expect the others to do so. And that's what happened in this case. The defense talks about, we don't want you to have the truth. That could be farther from the truth. Let's talk about Mr. Rosales. I asked Detective Richardson, based upon the statement that Mr. Rosales gave to detectives in this case, was it consistent with the information and the evidence that you gathered during the course of your investigation? The answer was no. Why would we present a witness to you like that? Why would we present a witness to you that's not going to be truthful? We wouldn't do that. Let's say you were trying to hide Mr. Rosales. We're trying to hide Detective Embry with the Sheriff's Department who did this speed analysis. Well, let's talk about what Detective Embry did. I asked Mr. Johnson, did you review these calculations that Detective Embry did? He said, yes, I reviewed them. Well, what did you think of them? They were totally inaccurate, totally wrong. The methods that he used were incorrect. He basically used his visual eyes to look at a screen, looking at the video, and use a stopwatch to do the time. He went out to the scene, he took a tape measure, and he measured the panels on the fence to do distance. Again, it's not accurate. Defense counsel told me that his numbers were twice the numbers that Mr. Johnson and Mr. Partain came up with using methods that are far more exact and far more specific and far more reliable. That's why we didn't call Detective Embry. But they want to tell you that we're trying to hide evidence. defense counsel says that the defendant used deadly force because Ms. Dawes was out of control that evening. She was going to do anything to get up out of there, including murder all the officers, which you didn't see on the video whatsoever. And that he was going to stop her before it was possible that she hurt anybody that night. Again, there's that word, possible, probable, next step, next course of conduct, next course of action. Again, the law doesn't work that way. Whether or not it's immediately necessary at the time the deadly force is used. Think about this. And we did the same way. Think about pulling out of a parking space at the grocery store. Pulling out of a parking spot at the mall as you get ready to leave. If this conduct by the defendant that day was acceptable, exemplary, as the defendant lawyer would have you believe, then we're all in trouble. Because in that particular situation, somebody can use deadly force against you. And that would be considered acceptable. I will submit to you that that's not acceptable by anyone, let alone a Dallas police officer who's tasked with protecting and serving. Again, we don't condone the actions of Ms. Dawes that night. Okay? Situation where, again, police were called, should have been police contact, some investigation should have occurred. It's possible she could have went to jail that night. But again, disobeying an officer's commands, fleeing in a motor vehicle, does not give cause for a Dallas police officer to shoot and kill anyone. And if today by your verdict, you say not guilty, you're saying that conduct is acceptable in our society. I said in my opening statement that again, we here at the DA's office, we work with good, hard-working police officers every single day. The majority of them do great work. They follow the law, they do their job, they go home at night. But in this situation, with this defendant, the manner in which he used deadly force on Ms. Dawes, the manner in which he disregarded all the information that he had at that time.
You have 2 minutes.
Thank you, Your Honor. The manner in which he shot 12 shots into this vehicle. First, a volley of 9, a break, no reassessment, no looking over to make sure that nobody's behind the vehicle, and then 3 more shots, hitting her multiple times and killing her. Not to mention, if he actually really believed that there were officers over there, and he's putting bullets toward them as well, talking about considering your target in the backdrop. Again, not reasonable. I'm going to ask you to find him guilty of this offense today. Again, your verdict today of guilty is not a message to all officers that we don't support you, because we do. Your verdict of guilty today will send a message that this particular type of conduct would not be accepted in our society, and he needs to be held responsible for his actions. We're going to find him guilty. Thank you.
Thank you, Mr. Lewis. You may be seated. Members of the jury, I'm going to send you back. It'll be a few minutes, but we will get all of the evidence that was admitted to you for all purposes as soon as we possibly can. To the alternate juror, I'm going to have some additional instructions for you right now. Please don't discuss this case with anybody else. Please let me know if anybody approaches you, if anybody talks to you, makes you feel uncomfortable. For any way, let the court know through the bailiffs who have you in their charge. I'm going to talk to you further about ways that I can get in contact with you and have some additional instructions about where you're going to be while the jurors deliberate. Members of the jury, you are only allowed to deliberate when all 12 of you are present. Please mind the instructions that I've given to you. Good luck during your deliberations. All rise for the jury. Mr. Lewis, Ms. Madsen, can I see y'all very briefly? Thank you. Court's in recess. Do we have a cloud computer that I want you videos on?